इसको जस्टिफाई करना होगा नीचे कोर्ट में।
नहीं तो आपने तो यहाँ पे 22 तारीख 2022 से चल ही रहा है ना, तो दिस पीरियड विल अल्टीमेटली बी curtailed, right? Right? Then I will record your submissions accordingly, right? That he has a right to file fresh complaint in view of such and such. हाँ?
तो हम उस पे उस दिन भी जो आर्गुमेंट है इसीलिए हम ऑब्जेक्शन किए थे कि नहीं ये, लेकिन बेटर है कि फिर ज़्यादा है हम लोग
प्रीमैच्योर है मिलॉर्ड, तो ये तो कंप्लेंट तो है ही नहीं,
हाँ।
तो है ही नहीं, तो फिर मेरिट पे तो जाने से
कुछ पर्पस नहीं,
तो फिर से इसको जो है रिपोर्ट बैक कर दिया,
उतना ही ऑब्जर्वेशन से हो जाएगा,
बस इनको उतना से हो जाएगा
और आपको इस पे कोई ऑब्जेक्शन नहीं, ठीक है? Criminal Revision number 412 of 2022. The learned counsel for the parties are present. This case was heard on the merits of the case, on its merits on 15 February 2024, and the arguments were concluded and the case was posted for judgment today. Today when the case is posted for judgment, this court has the learned counsel appearing this court has pointed out that an issue would crop up in the present case as to whether the present criminal revision itself is maintainable or not. And therefore, the judgment on the basis of order dated 15 February 2024 has not been pronounced today, and this court proposed to place this case on the point of maintainability of the present criminal revision. Upon this, the learned counsel for the petitioner has submitted that the impugned order of acquittal has been passed on the ground that the complaint itself was premature, and therefore he will have the right to file a fresh complaint in view of the judgment passed by Honorable Supreme Court in the case of Yogendra Pratap Singh versus Savitri Pandey and another, reported in bracket 2014 bracket close 10 SCC 713, and therefore he seeks to withdraw this revision, and so that he may avail the remedy of filing a fresh complaint. The learned counsel appearing on behalf of opposite party number 2 has no objection to the prayer made. He has also submitted that the petitioner has a remedy of filing a fresh complaint, and therefore he may avail the adequate remedy. In view of the aforesaid submissions made by the petitioner and the opposite party number 2, this court permits the petitioner to withdraw this revision application so that the petitioner may avail his remedy in accordance with it. Right? आप साइन करना होगा आपको.
क्लियर हो जाता तो हम लोग भी आ रहे हैं.
Sorry?
क्रिमिनल रिवीजन और एक्विटल
नहीं इसको क्लियर होगा, आप चिंता नहीं करिए, ठीक है? एक ऑर्डर मैंने किया है और कुछ ऑर्डर्स मैं डीबी में रेफर भी करूँगी. आई एम जस्ट फिगरिंग इट आउट, क्योंकि ये बहुत ज़्यादा कन्फ्यूजन है. कंप्लेंट केस पुलिस केस का अलग प्रोविजन है, दूसरा बात एक्यूटल का अलग प्रोविजन है, इनएडिक्वेट कॉम्पनसेशन इनएडिक्वेट पनिशमेंट का अलग प्रोविजन है, राइट? विक्टिम का राइट अगेंस्ट द ऑर्डर ऑफ एक्यूटल पास बाय द ट्रायल कोर्ट एंड विक्टिम का राइट अगेंस्ट द ऑर्डर ऑफ एक्यूटल पास बाय द एपेलेट कोर्ट, इसको भी आइडेंट आउट करने की ज़रूरत है. हर एक सिचुएशन को अलग अलग डील करना, ठीक है? वो तुकालाल वाला जजमेंट में हम देख रहे थे, हमको बहुत क्लियर नहीं हो पा रहा है. मतलब आई एम जस्ट ट्राइंग टू स्टिल फिगर आउट कि मतलब उसका क्या इम्पोर्ट है, और उसके बाद सब्सिक्वेंट जजमेंट्स हमारे, इसलिए हो सकता है कुछ मैटर्स को हमको डिविजन बेंच में रेफर करना पड़े, लेकिन इसको हम लोग करेंगे ज़रूर. आप लोग का भी ड्यूटी है, स्टेट का कम से कम ड्यूटी है, अलग अलग कोर्ट से अलग अलग ऑर्डर्स पास होते हैं, आप लोग को कुछ खबर नहीं रहता, यू डोंट प्लेस इट, यू आर नॉट ए न्यूट्रल, यू आर ए न्यूट्रल पर्सन, बट एटलीस्ट प्रोसीजरल एस्पेक्ट में तो इन NI एक्ट प्रोसीजरल एस्पेक्ट में तो आपको देखना ही पड़ेगा ना, मेंटेनेबल है नहीं है। यू आर जस्ट ए साइलेंट स्पेक्टेटर, फाइल लेके स्टेट काउंसिल खड़े हो जाते हैं कि हमको कुछ कहना ही नहीं है। This is not the way the cases should be conducted. Anyways, that should be sufficient so far as
Yes,
this case is
yes.
concerned, right?
WPS press filing matter publishing.
So we call it the mistakes.
Under heading for final disposal, item 2, WPS 91 of 2023.
Lord, in this case, petitioner's father, late Ganesh Gurai, was a permanent employee of the company. And in the year 2006, on the charge of unauthorized,
Date बताइए।
16/2/2006,
26/6.
16/2/2006, on the charge of unauthorized absence, he was removed from the employment of the company. Then in the year 2016, by an order dated 11/5/16, ex-employee, deceased employee, father of the petitioner, was reinstated as Badli workman. Badli workman, means he will work in place of a permanent workman on his temporary absence. And he was reinstated in initial basic of category 1 wages. Category 1 wages.
That doesn't make any difference.
On joining, he joined on 29/6/16 at Churi project. And since then he continuously worked for more than 240 days in 12 calendar months. He died on 16/12/20.
Pardon, Lordship.
एक मिनट,
Fact लिखा देते हैं. Lordship, he is against. Pardon, Lordship. एक fact लिखा देते हैं. Again, he charge sheeted on 29/10/2018.
29/10
2018.
dismissed.
No, not dismissed. Charge sheeted.
No action was taken, only charge sheet. After completion of 240 days attendance.
No action was taken ultimately.
Lordship, action is going on. Charge sheeted only.
Action is still going on against a dead person.
Yes.
Have you issued? From where do you say that action is going on?
Lordship, I have attached.
No, attached. No. What do you? Or do you want to say that the proceeding is still going on?
Still, before died Lordship,
We'll deal with it.
I will come to that.
डिसमिस नहीं ना किए हैं?
नहीं
डेड आदमी को डिसमिस करने का मन है आपको?
नहीं वो नहीं तो I drop.
Yes.
He died on 16/12/20. And then employment of compassionate appointment under 930 of Prakash Gurai petitioner was rejected by the improved order dated 23/2/2022 on the ground that dependent of a Badli worker is not entitled for employment under NCWA. A Badli workman is covered under certified standing order of the company. In my rejoinder petition, clause 3.1 at page number 36, my lord. Otherwise, also, my lord, under clause 3.3, because he has completed 240 days and more attendance, he ceased to be a Badli workman. He ceased to be.
What do you have to say to the judgment passed in
My lord,
AP number 393?
My lord,
Just
now
straight
I
away
am
come.
coming to the judgment, my lord. Your
You
Lordship.
just need to respond to LPA number
My
393
Lord,
and
my
17.
Lord. This case, my case is distinguishable, my Lord. Only on the ground that the LPA 393/2017, which they have relied, is a case of ex-employee who was appointed as trainee on stipend of ₹25,000 per month.
Not a case of badli work.
Not a case of badli workman. He
इसको सुनने दीजिए हाँ बोलिए क्या बोल-
Lordship, father of the petitioner reappointed. Kindly see my counter. In Esther A. Lordship, kindly see
Initially.
page 17.
Yes.
मैं रिफर पैराग्राफ 1 सब
ठीक है इसमें क्या रेफर करना है
he is appointed as category 1 subject to the regularization of the certain conditions, Lordship.
Yes.
And Lordship, kindly see Annexure C, page 20. Office order, page 20, Lordship. Ganesh Purohit, designation category 1. He is appointed as a category 1 subject to the and the one, Lordship, I have referred 9, page 17, clause 9, Lordship. Ganesh Purohit shall be treated as date of his fresh appointment. And
Page 17,
clause 9, Lordship.
clause 9, the date of reinstatement.
Yes.
Yes.
Date, he shall be treated of his.
कहाँ लिखे है treated? Yeah, clause 19 is something else. You read clause 19.
The date of reinstatement of the Ganesh Purohit shall be treated as a date of his fresh appointment. Page 17, Lordship.
Page 17, para
Annexure-
number, annexure A,
Annexure A, Lordship.
para number,
Clause 9, Lordship.
clause 9. Read it, the date of reinstatement.
Ganesh Purohit shall be treated as a date of his fresh appointment, and his past service shall not be calculated calculation for the graduate. Lordship, my humble submission is father of petitioner has not challenged his
No problem. He is a badli worker.
He is a badli worker as a category 1, and his regularization is subject to certain conditions, Lordship.
Yes. What condition?
Lordship, kindly see clause 4, Annexure A. First clause 3 and clause 4. I agree.
Read it.
Ganesh Purohit shall be considered for confirmation as permanent employee in category 1 on completion of 190 days of physical attendance in case of underground and 240 days of physical in case of surface such and such. And thereafter, Lordship, in case 4, in the event Sri Ganesh Purohit does not complete 120 days, 12. He is completed, Lordship, and the case referring 393, Lordship, is exactly similar, Lordship, because in this case also, Lordship,
He was appointed as badli worker or he was not appointed as badli worker?
He is appointed as category 1, basic
No,
category.
but your impugned order is talking about that he was appointed as badli worker.
Badli worker as category 1, Lordship.
Whatever, how does that make a difference?
Difference is that the badli worker cannot be his substitution on the other category.
We do not know. He
Lordship,
was a badli worker or he was not a badli worker?
he designation, Lordship, can you see?
Designation, badli worker has different categories.
Yes, Lordship.
From where do you say this?
It is impugned in annexure C,
No,
Lordship.
you read your counter affidavit paragraphs, right? Don't read from the
Lordship,
annexures.
I am going, Lordship.
You go through your counter affidavit.
Lordship, can you see annexure D? Annexure D?
No, not annexure D. What is your stand in the counter affidavit?
Yes,
You
yes.
read it from the counter affidavit.
Yes.
Lord, may I, just a minute, may I?
Regularization of petitioner is proceeding for regularization of petitioner is going on, Lordship.
No. You read it from your statement made in the counter affidavit.
Yes, Lordship.
Okay,
Yes.
please read it.
That
Para number 10.
para
Para 10.
para
You
six-
start from para 10. Para 10.
negligence was removed from service for इतना भी defective से white such and such. The Ganesh Purohit reinstated Badli worker white ordered and such and such and such. Thereafter,
He was reinstated as Badli worker. It is a statement in the counter affidavit. You cannot argue beyond your counter affidavit, right? You read further.
after incident, the father of petitioner number 1, namely Ganesh Purohit, had reported his duty such and such and such. A Badli worker in initial basic category 1, category of NCW, initial basic category. Lordship, instead, para 14, Lordship. Now I refer para 14. The proposal for regularization of father of petitioner number 1, that Ganesh Purohit had been initiated with all requisite documents and sent it to the area for approval, sought from the confirmation in category 1, Lordship. My humble submission is, Lordship, he is regularized after certain period in his basic category, Lordship, not a Badli worker. Since he appointed as category
He was regularized.
No, Lordship, process is going on.
So therefore, he was not regularized.
No,
He
no.
was supposed to be regularized under category 1, but he
Yes.
was not regularized.
Not regularized.
So he continues to be Badli worker only.
No, Lordship. She continued as category 1. Before regularization, he was category 1, Lordship. And in
No, आप कोई दूसरा भाषा में बात
नहीं।
करिए, ठीक है? आपकी अंग्रेजी समझ नहीं आ रही हमको।
जो इनका
आप
हमारा
हमको इतना बात बताइए कि उनको बदली वर्कर की तरह अपॉइंटमेंट किए।
कैटेगरी 1 हम लोग हमको
इस कैटेगरी से क्या लेना देना है?
कैटेगरी की अगर ये इनका सर्टेन कंडीशन अगर फुलफिल करते हैं, लॉर्डशिप काइंडली सी रिफर आई हैव रिफर द जजमेंट एलपीए नंबर 390।
नहीं, आप एलपीए फैक्ट पे नहीं आते हैं, एलपीए के जजमेंट पे पहुंच जाते
हैं। इसमें भी जो इनके इसमें हमने क्लॉज 3 और 4 जो पढ़ाया है, हम
पढ़ लिए।
उसमें है कि अगर 240 दिन का अगर वो करते हैं, पूरा कर लेते हैं अटेंडेंस, तब उनको कंटिन्यू किया जाएगा। इस केस में भी यही है कि बिफोर कंटिन्यूइंग हिज सर्विस ही petitioner was died. So
what is his status? Before confirmation, if he dies, what is his status?
He is not a permanent employee, and I rejected his claim that he was not a permanent employee.
Then you come to this 3.3,
yes.
Page 37. You did it. Page 37 of the rejoinder.
Badli or substitute is one of the appointed in the post of permanent workman or probationer who is temporarily absent, but he was case to be Badli on completion of continuous period of service of 1 year.
But he would cease to be a
yes.
जब 1 साल हो गया, 240 दिन हो गया, he is deemed to be a permanent worker as per your NCW. आप ही ने बनाया है ना?
Yes.
अब क्या बोलना आपको?
मेरा यही कहना कि जजमेंट इवन सुप्रीम कोर्ट लॉर्डशिप आल्सो हैड देयर इज नथिंग लाइक परमानेंट ऑटोमेटिक कंफर्मेशन इन दिस केस।
आप ही ने बनाया ये deemed to be, he will deemed to be permanent after completion of probationary period.
In this case lordship said that if there is not stated that thereafter he is automatically
so according to you his status was that of a badli worker or his status was that of a
his category 1 not permanent.
Category 1 not permanent.
Yes.
इसका क्या मतलब है?
He appointed as category 1 but before that he was not permanent. So
he
there
was
is nothing
appointed,
like
you
a
cannot
automatic
forget
confirmation.
that he was appointed as a badli worker
in category 1
whatever be the category. And
Lordship,
this and the other judgment of this court you have seen?
Yes lordship. First lordship kindly may place permitted to place the judgment lordship 393.
393.
Yes. Page 27 lordship. Para regions. Internal page 27. regions. Having heard that for the both counsel looking the facts as the case, we hereby quest and set aside the order passed by learned single judge in such and such and such and mainly on the following judicial pronouncement. Lordship can clause 5 lordship, I will refer. Looking the appointment letter, it appears Nageshwar Mala was appointed training with a monthly stipend of Pitna. Has mentioned clause number 1 that upon successful completion of the training period, he may put on regular basis or his period of training can be extended. Thereafter, Lordship 6, it appeared that 1 year was over and he was not confirmed. There is nothing like automatic conversion even if a associate period of 1 year is over. Thereafter, Lordship, page 29. It is held that the Supreme Court GS such and such parade. Thereafter, Lordship, kindly permit. It is further been argued that on basis of rule such and such, petitioner has worked for more than 2 years on probation. They became automatically confirmed under the said rule. And reliance.
That's it. We have seen. क्या बोलना आपको और बताइए.
It has been held that the case of the probationer cannot be the expiry of probationary period.
He was not on probation. The petitioner was not on probation. He was on as a badli worker.
Badli worker, my humble
just one line, if I am permitted,
You see page number 36.
36.
Badli or substitute and probationer are 2 different categories.
But
as per your NCWA.
certified standing order.
Yes, sorry, certified standing order. Badli is different from probationer as per your certified standing order. चलिए ठीक है सुन लिया.
One line. The issue is not confirmation, my lord. Even admittedly he is a badli workman, the issue is whether dependent of a badli workman is entitled for employment. See the issue.
WPS number 19-1 of 2023. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner was in service of the respondents with effect from 16/2/2006 and he was discontinued in service.
Removed,
He was removed from service and subsequently by order dated 11/5/2016, he was reinstated as badli worker. And he reported for duty on 29/6/2016 and he expired on 16/12/2020. He submits that the father of the petitioner was never removed from service. The learned counsel and continued to be badli worker.
It is not by he was removed earlier, thereafter he was not removed.
The father of the petitioner was appointed as badli worker and he was as such no order of regularization was passed with respect to the father of the petitioner. The learned counsel has referred to the standing order,
certified standing order.
Certified standing order, and has submitted that different categories of workmen has been mentioned. Badli or substitute is mentioned at clause 3.1 1B. He has also referred to clause 3.3 to submit that there is a provision for, as per the said provision, a budly working in place of a probationer
or probationer who is appointed in the post of permanent workman or probationer who is temporarily absent.
Okay, he has submitted that a budly or substitute who is appointed in the post of permanent worker or probationer who is temporarily absent, but he would seem to be a budly on completion. He would cease to be a budly on completion of a continuous period of service for 1 year. The learned counsel submits that the requisite period was duly completed by the father of the petition, and accordingly he submits that the petitioner was entitled for compassionate appointment, and for this he has referred to judgment passed by this court in WPL number 5398 of 2005, dated
Found in LPA 273.
just
Page number 16 of the
next. Dated 14th August 2019, and the said judgment was affirmed in LPA number 273 of 2020. The learned counsel, appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that a charge sheet was issued to the father of the petitioner on 29/10/2018, and before the proceeding could be taken to a logical end, the father of the petitioner expired on 16/12/2020. The learned counsel has also submitted that
Before regularization.
and the father of the petitioner had expired before an order of regularization could be passed. However, it is not in dispute that father of the petitioner was appointed as budly worker. Budly आपका काउंटर में है ना? The learned counsel has relied upon a judgment passed by this court in LPA number 393 of 2017 and has submitted that there is no concept of automatic confirmation in service,
Yes.
and the said case was arising out of the claim for compassionate appointment.
Yes, sir.
Claim for compassionate appointment in which the ex-employee was a trainee
But died before compulsion.
and he expired before he could be confirmed. That's all. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that initially the father of the petitioner was working since 16 to 2006 and thereafter he was removed from service. However, on 11/5/2016, he was reinstated as a budly worker and he joined as budly worker on 29/6/2016. In the counter affidavit at Annexure D, a document has been placed on record which is dated 28/8/2019, issued by the respondents, giving the total period of attendance of the father of the petitioner as 265 days, and also indicating that the father of that as per point number 3 of the order of reinstatement dated 11/5/2016, the father of the petitioner shall be considered for confirmation as permanent employee in category 1 on completion of 190 days of physical attendance in case of underground and 240 days of physical attendance in case of surface, as the case may be, in immediately following 12 calendar months from the date of his joining on reinstatement. It was recorded that the father of the petitioner had completed 265 days of attendance till 15/5/2017. This court also finds that, however, no order of regularization in the services as category 1 of the father of the petitioner who was working as Badli worker was passed by the respondents, and in fact on 29/10/2018 and as per the case of the respondents, a charge sheet was issued to the father of the petitioner on 29/10/2018 on account of unauthorized absence.
Yes.
On yes बोलने के पहले check कर लीजिए भाई.
Yes, I have stated.
On account of unauthorized absence. However, before the proceeding could be taken to a logical end, the father of the petitioner expired on 16/12/2020. No final order in connection with the disciplinary proceedings initiated on 29/10/2018 has been placed on record. This court finds that the petitioner applied for compassionate appointment, and his claim for compassionate appointment was rejected by the impugned order dated 23/2/2022 by mentioning that that employment under paragraph 9.3.0 of NCWA is provided to one of the dependent of deceased employee if the said employee was a permanent workman of the company. And since late Ganesh Godait was a Badli worker and he died before regularization as permanent workman, the claim was declined. The provisions of the standing order with regard to classification of workmen as placed on record by the petitioner in the rejoinder is as follows. Clause 3.1 को quote करिएगा. Upon perusal of clause 3.1, it appears that the badli or substitute is a different category from that of a probationer. It further appears from clause 3.3. Further, clause 3.3 of the standing order provides that one who is appointed in the post provides that badli or substitute is one who is appointed in the post of permanent worker or probationer who is temporarily absent but would cease to be a badli on completion of a continuous period of service of 1 year within bracket 190 attendance in case of below ground workmen and 240 attendances in case of any other workmen, bracket close, in the same post or other post or post in the same category. A badli worker in place of a probationer would be deemed to be permanent after completion of the probationary period. This court finds that the respondents have themselves certified White annexure D to the counter affidavit that the father of the petitioner had completed the required period of for his regularization, inasmuch as he had completed 265 days of attendance in one calendar year, but ultimately no order of regularization was passed. This court also finds that in case of badli or substitute, there is a provision under the work standing order that upon completion of the requisite period, the badli would be deemed to be the status of badli will cease to be a badli on completion of the period, and he will be deemed to be permanent. However, admittedly, no formal order in connection with permanent employment of the father of the petitioner was passed, and the impugned order only reflects that the claim for compassionate appointment was declined as the father of the petitioner was a badli worker. Considering the clause 3.3 of the standing order, and considering the admitted fact that father of the petitioner had completed 240 days attendance and had in fact completed 256 days as per the records of the respondents, the status of the father of the petitioner ceased to be badli on completion of the requisite period, and he was deemed to be permanent, although no formal order of being permanent was passed. This is over and above the fact that in the judgment passed by this court in WPL number 5398.8 of 2005, which was arising out of an industrial dispute in reference case number 228 of 1998, and the award was challenged by the employer BCCL. The standing order of BCCL was taken into consideration, in which also there was a concept of badli or substitute, and also probationers. And this court held that the status of worker as badli worker would not have made any difference, as the definition of worker provided under clause 7.1 of the standing order contains badli worker also, and therefore badli worker is a worker under the petitioner company, and dependent of worker was entitled for compassionate appointment if he or she died in harness as per clause 9.4.2 of NCW Roman 4. And therefore the contention of BCCL was rejected. The said judgment was subject matter of consideration in LPA number 273 of 2020, and the appeal was dismissed. This court finds that even if the status of the father of the petitioner is considered to be that of Badli worker, as mentioned in the impugned order, then also the claim of the petitioner could not have been rejected in view of the judgment passed in WPL number 5398 of 2005, upheld in LPA number 273 of 2020. This is over and above the fact that upon reading of the provisions of clause 3.1 of the standing order, read with clause 3.3, the status of a Badli worker ceases to be so on completion of the requisite period of 240 days. And that admittedly the father of the petitioner completed more than 240 days as per the records of correspondence. So far as the judgment passed in LP number 393 of 2017 is concerned, the same was arising out of a claim for compassionate appointment in connection with a person whose father was trainee appointed as on stipend of rupees 2500 with a condition that upon successful completion of trainee period he may be put on regular basis or his period of his training could be extended. And upon completion of 1 year, he was not confirmed, and the plea of the workman was and in the meantime he had expired. The plea of the son of the deceased employee was that upon completion of 1 year, his father ought to have been treated as confirmed. Such plea was rejected by Honorable Division Bench in LPA number 393 of 2017. This court finds that not only the status of a trainee, not only the status with regard to a trainee is different from that of a Badli worker, as there are different categories of workmen, and Badli or substitute is a distinct category altogether. Moreover, the terms and conditions of employment of trainee was totally different, inasmuch as there was no clause of any automatic confirmation in the terms and conditions. There was a clear stipulation that upon successful completion of trainee period, the trainee may be put on regular basis or his period of trainee could be extended. However, in case of Badli or substitute, the clause 3.3 is totally distinct, and it clearly provides that upon successful completion of the requisite period, the badli would cease to be a badli and he would be deemed to be permanent. In such circumstances, the judgment passed in LPA number 393 of 2017 does not apply to the facts and circumstances of this case. So far as the argument of the respondents that a charge sheet was issued to the father of the petitioner on 29/10/2018 prior to his death is concerned, no proceeding or order in connection with the charge sheet has been placed on record to show that, and in fact the records reflect that no final order was passed, and in the meantime the father of the petitioner expired on 16/12/2020, and therefore the respondents cannot take any advantage of the charge sheet dated 29/10/2018. Considering the totality of facts and circumstances of this case and in view of the aforesaid findings, this court is of the considered view that the impugned order rejecting the case of compassionate appointment of the petitioner on the ground that father of the petitioner was a badli worker and he died before regularization as permanent workman cannot be sustained in the eyes of law and is accordingly set aside. The respondent number, who will consider your matter?
Respondent number 2, Madam. Director.
The respondent number 2 is directed to consider the claim of compassionate appointment of the petitioner subject to satisfaction of other requisites or criteria for grant of compassionate appointment. The needful will be done within a period of 1 month from the date of receipt of a copy of this order along with a copy of the date records. This petition is accordingly disposed of.
Some more time.
1 महीना तो LPA के लिए है और 2 महीना हम टाइम दिए हैं, काफी ठीक. If the petitioner is found entitled for compassionate appointment, the respondent number 2 shall pass a recent order in connection with the claim of the petitioner. And if the the recent order be communicated to the petitioner through speed post. If the petitioner is found entitled for compassionate appointment, necessary follow-up orders be passed within a period of 1 month from the date of the recent order.
Item 3, WPS 364 of 2023.
On the last date, the petitioner was directed to file supplementary affidavit to bring
You
on
see,
record.
he has been convicted.
Yes,
It is
ma'am.
the same offence, same incident. Arising out of the same incident, he has been. The departmental proceeding was arising out of the same incident,
Yes, Your Lordship.
isn't it? Now he has been convicted. What relief can be granted to him? If he is ultimately acquitted, then we'll see what is to be done.
Yes, Your Lordship. For that only supplementary was to be filed by petitioner.
No,
but it
he
does
was
not.
to file the supplementary as to when he was released from
When he was
custody.
released, yeah. Yes, Your Lordship.
But even if that comes, how will it serve his purpose? Because he has already been convicted.
Convicted. And the
So we can just dispose this matter by saying that if he is ultimately acquitted, then he may have some cause of
because
action.
criminal case is still pending, Your Lordship.
Yes. He has said that He has mentioned about the criminal case. You have mentioned it in the counter affidavit.
Which one?
The criminal case.
Criminal case. Consideration. In my counter affidavit, it's mentioned. Annexure A.
We are just passing it over. If he doesn't come, we'll pass appropriate order. Just check only one thing, whether it is arising out of the same incident. Please check it up. We'll take it up at 1 o'clock. 1 o'clock.
Item 4 WPS 901 of 2023.
ये वाला ऑर्डर दे दीजिए. You are ready to give this amount, and you just give them a hearing about this. They say that it was already adjusted or whatever.
They only say by board, but they have not produced any evidence.
They might not have. They may have some evidence. So far as that is concerned, but you give them the, what do you say? You deposit this amount. You have already said that you are ready to deposit the entire amount.
Yes,
Then there is no problem.
No problem.
Okay. Should I record your undertaking that you are ready to deposit? You have stated so in your rejoinder.
I'm very good.
That is the only amount.
That is the only one.
WPS number 901 of 2023. Counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner is ready to deposit the entire amount of rupees 1,59,332 as claimed against the petitioner, and upon such deposit, the respondents should be directed to expedite the issuance of no due certificate so that the petitioner is ultimately granted the post-retirement benefits. किसके पास जाना पड़ेगा?
जहाँ से लास्ट टाइम ये रिटायर्ड हुए, जिस ऑफिस में लास्ट टाइम काम कर रहे थे, मैं उससे
At this, the learned counsel for the respondents has submitted that the petitioner will have to approach the district engineer Zilla Parishad Lohardaga, from where the petitioner had superannuated on 31/12/2019, and upon deposit of the amount, the no due certificate will be issued to the petitioner. Correct?
Yes, ma'am.
And thereafter, the petitioner may take appropriate steps, and thereafter the respondent shall take appropriate steps so that the post-retirement dues are paid to the petitioner. After hearing the learned counsel for the parties and considering the aforesaid submissions, this petition is disposed of, enabling the petitioner to approach the district engineer Zilla Parishad Lohardaga to deposit an amount of rupees 1,59,332, and upon such deposit, the no due certificate be issued to the petitioner within a period of 1 week from the date of such deposit, and the said authority shall also take appropriate steps so that the post-retirement benefits, appropriate steps within a period of 15 days thereafter, so that the matter regarding payment of post-retirement benefits to the petitioner is also expedited. That's it. The state petition is accordingly disposed of.
Appearance is due. Item 5 WPS 977 of 2023.
Playing for not today. Though he has come today, but
No. You have not given any advance notice of adjournment, and I will.
no, let's see, the Mr. Kumar has come today, the High Court, and suddenly he has vomited and that is not good, that's why. He is present today in court premises. That's why I'm trying to not today only.
Anyways, you come to this page. You don't have the brief. Show it to me.
Let it be password, I can.
No, I just indicate ना कल को वो फिर टाइम मांगे.
नहीं वो आए थे उनका तबीयत जस्ट
नहीं हम टाइम देंगे आप.
जी.
लेकिन थोड़ा चीजों को समझ
जी,
लीजिए
जी.
ना. समझ लीजिए उनको
जी.
बता दीजिए. Annexure C of you just see the counter affidavit.
Supplementary counter affidavit.
Not the supplementary, the counter affidavit. Para number 13.
That is the main one.
They claim the date of birth as
37.
बताइए date of birth according to you, but according to him.
37 years.
No, what is the date of birth? He has given exact date of birth.
28/7/1985. As per all the documents.
No, as per his case.
As per his case, the date of birth is 1/7/1989.
1/7/1980, right? Para 13 में आपका नाम LTC में 1988 में. सपना तो नहीं आया होगा आपके पिताजी. 88 में your name is appearing in LTC form. Prior to the date you claim to have been born. Right?
And Nitisha, one more thing. This date of birth, the birth certificate and all that, that has been issued later, subsequent.
You forget it. But this is so clinching.
Service records are accepted to be.
Service record, your name is appearing in the service record prior to the date of birth you claim. समझ में आ गया ना?
Yes, we will answer it.
Answer आप answer करें. The learned counsel for the parties are present. During the course of hearing of this case, it transpired that the petitioner is claiming that his date of birth is 1/7/1989, and as per the respondents in the counter affidavit at para 13, it has been specifically mentioned that in LTC form, the age of the petitioner was shown as 4 years as on 1/12/1988. It goes to show that the birth of the petitioner was acknowledged by his father as back as on 1/12/1988, and the petitioner claims that his date of birth is 1/7/1988. A rejoinder to this counter affidavit has also been filed, but this aspect of the matter is not in dispute. At this, counsel for the petitioner seeks adjournment. Post tomorrow, part 30.
If we
साढ़े
have
दस
to
बजे.
tomorrow, day after tomorrow.
क्यों? अभी तक tomorrow बोल रहे थे.
Tomorrow जाएंगे मेडिकल कुछ इसी डे after.
Post day after tomorrow.
Okay.
First case at 10:30.
Item 6 WPS 1663 of 2023.
In this case, the petitioner who was working as a computer operator is claiming honorarium in terms of the direction issued by the finance department in terms of the resolution of the finance department.
That is not happening.
Because now they have come out with an affidavit, counter affidavit, that I was not working as a computer operator, I was working on a daily wager. The whole I'll just brief only to two aspects. The resolution 26/2017 is on record, annexure 1, page 15. May kindly have a glance to this. I'm only claiming the honorarium which is payable to the computer operator. Annexure 1, page 15 got. This is the resolution of the minutes, and this is in relation to the computer operator and all. And as per this resolution, page 16, if has a glance. The computer operator, this is the honorarium which has to be paid. Milords got that.
This is PP pay band. This is for regular computer.
No, Milords.
computer operators.
अन्य कार्यालयों में संविदा राशि उसके बगल वाला कॉलम में देखिए ना।
हाँ.
अन्य कार्यालयों में एकमुश्त संविदा राशि प्रति माह। The third column I am referring to. I am entitled to this 26,300 which
What is अन्य कार्यालय?
अन्य मतलब Milords in other establishments of the government. Milords, this is by the finance department. And I will clarify, Milords, that this has been duly implemented with respect to the Greek Kara Vibhag under which I was working. Kindly have
No,
a glance.
where you ever paid this amount?
No, Milords.
Where is your appointment letter?
Milords, so far the appointment letter is concerned, Milords. My joining is there, Milords. Milords,
No,
only
where
one.
is your appointment letter?
The
You have to
computer.
show your appointment letter. It can't be like this.
Milords, I am only referring to one page.
We can understand that you are appointed on a contractual basis.
Milords, I am working as a contract.
No,
that,
no.
that
How
is
do,
not.
they say that you are working as a daily wager. Daily
No.
wager is not contractual.
And we are also saying
Right.
that we are not
Show me your appointment letter, and then we will see whether your appointment was in terms of. And since when are you working?
2017 onwards, Milords. I
What
have
is
brought-
the date?
Milords, the date is there, Milords. Annexure, Milords, I have brought on record,
You
Milords.
give your specific date.
Annexure 5, page 10, Milords. Annexure 5, page 10 of my rejoinder, Milords.
You give your specific date.
6/5/2018.
You are working since 6/5/2018.
2018.
now is not working.
Now I am not working. They are 6 annexure 5 Milords. I am referring to page 10 Milords.
Of the rejoinder.
Rejoinder.
ये क्या है?
This
ये
is
तो
my
आपका चिट्ठी।
जी स्थापना जेल योगदान स्वीकृत किया जाता है. This is by the jail superintendent. And thereafter, Milords,
नहीं आप बताइए, आप पढ़िए इसको जरा।
अधीक्षक महोदय, मंडल कारा लोहारगार, कारापाल महोदय, कारा पर कंप्यूटर ऑपरेटर के पद पर योगदान देने के संबंध में निवेदन पूर्वक कहना है कि मैं सो इस कारा में दिनांक
नहीं, ऐसा
6
नहीं। देखिए कॉन्ट्रैक्चुअल अपॉइंटमेंट भी जो हो रहा है कंप्यूटर ऑपरेटर का, उसमें भी एडवर्टाइजमेंट होता है। It is not just like this.
Milords,
Is it followed by any advertisement?
No, Milords, there was
Then-
no advertisement to that extent.
Then-
Milords, that I got on to
We also know that it for computer operators ad hoc की बजाय ad hoc appointment हो रहा है, but it is also through advertisement.
Milords, what I am submitting for my Lord's kind
We
consideration.
cannot.
Milords, one more page, Milords, if of the rejoinder only, page 11, Milords. This is also obtained under the Right to Information Act, Milords. Milords got that. Page 11 I am referring to, Milords. कारा महानिरीक्षक झारखंड के पत्रांकित नाम के क्रम में कारा में कार्यरत कंप्यूटर ऑपरेटर वीसी ऑपरेटर के मानदेय में वृद्धि करते हुए वित्त विभाग में द रेजोल्यूशन ऑफ द वित्त विभाग सो को भुगतान करने का निर्देश प्राप्त किया है जो किया जा सकता है. सुमित चौहान कंप्यूटर ऑपरेटर एंड चंद्रमौली.
फिर आप यहाँ क्यों आ गए? वहीं जाइए जिसने आपके
in
फेवर
spite
में
of this, Milords, they are not
we
taking.
cannot acknowledge this. इसको acknowledge करके reject कर सकते हैं, allow नहीं कर पाएंगे।
Milords, what I
आपको
respect.
परसू करना है, अपना रेमेडी परसू।
Milords, one thing else, Milords, I was just indicating, Milords, the association has also come. Milords, the next is the judgment passed by the coordinate bench, Milords, page 12. The association of Milords, the Kara Shramik, Milords, the Dainik Kara Karmik, Milords, in the Kara, they had also come before this honorable court for their regularization and for equal pay for equal work in terms of the judgment of the Jagjit Singh case, Milords. This honorable court, Milords, while taking into account that regularization cannot be granted, Milords, gave them liberty to represent before the concerned authorities for ventilating their grievances. Pursuant thereto,
That is
Milords,
not your case.
pursuant thereto,
You see, if you have already moved in
No,
that
Milords,
association,
because the association had moved, Milords,
no, and you have not mentioned that you are a part of that association,
that
you are a member
association-
of that
Milords, the
association. There is no mention in the writ
Milords,
petition
I
that
have
you
not
had
mentioned.
moved
No,
earlier.
Milords, I have not moved earlier, Milords, I am not, I am
No,
indicating.
when your association moves,
Milords.
it means that you move.
Milords, the association has moved in the year 2014 itself, Milords, for that, Milords. But
So
what I
that
am
is not the
respectful,
scope of the writ petition. We will not.
Milords, I am
enter
only
into
to
that.
the extent, Milords, that if there is a, Milords, the daily wager, contractual employees, they
Daily
all,
wager and contractual are different things.
Milords, my
altogether.
submission is to the extent that they are one and the same, Milords, and taking into account, Milords, only one judgment I will be referring to, Milords, the Jagjit Singh judgment, Milords, passed by the Supreme Court, Milords, where this bracket has been held and all of them had been held to be equally placed, Milords, in terms of that judgment. Only to
So
that
there is
extent.
no distinction between contractual employment and daily wage.
For the purposes of, Milords, the
No, not for the purposes. Otherwise,
I'm
there
only,
is any
I'm only
difference.
on to the Milords for the purposes of the wages, Milords, whether I am entitled or not, Milords, only to that extent.
Sure, where is the judgment?
Plus 2017. Here is it. Volume 1, SCC page number 148. The paragraph 6 of this. The facts have been dealt with, Milords. And while taking into account, Milords, the para 55 of the Uma Devi has also been considered, Milords.
You read para 6.
Milords. Para 6 I am just placing only for the factual aspect, Milords. That would be clear from there, Milords.
Read it, please.
Milords, I am sorry. The issue which has arisen for consideration in the present set of appeals necessitates a bird's eye view on the legal position declared by this court on the underlying ingredients, which governs the principle of equal pay for equal work. It is also necessary for resolving the controversy to determine the manner in which the court has extended the benefit of minimum of the regular pay scale along with dearness allowance as revised from time to time to temporary employees engaged on Milords daily wages basis, as ad hoc appointees, as employees engaged on casual basis, or as contract appointees and like. For the aforesaid purpose, we shall examine the above issue in two stages. We shall first examine situation where the principle of equal pay for equal work has been extended to employees engaged on regular basis, and thereafter how the same has been applied with respect to different categories of temporary employees. Now kindly have a glance to the paragraph 36 point of this and 44 of this judgment.
36 point?
36.2 I am referring to the Uma Devi has been considered 36.2 36 and para 44, and then I will come to the concluding part, that is 59. The entire judgments of the Honorable Apex Court on this field governing the field has been taken into account in this judgment. I am referring to paragraph number 36.2.
Yes, read it.
I am just. This paragraph 55 is also a bearing, because in the case of the Uma Devi also, this criteria was there, and para 52, 53 we remember, because that was in relation to the 10 years period, but para 55 is in relation to this, that is the reason I am placing this. The Constitution Bench, without having noticed the contentions of the rival parties on the subject of the wages payable to daily wages, recorded its conclusion as under. It was also with respect to a daily wages. In cases relating to services in commercial tax department, the High Court has directed that those engaged on daily wages be paid wages equal to the salary and allowances that are being paid to the regular employees of their cadre in the government service, with effect from the dates from which they have been respectively appointed. The objection taken was for the direction of the payment from the dates of engagement. We find that the High Court had clearly gone wrong in directing that these employees be paid salary equal to the salary and allowances that are being paid to the regular employees of their cadre in government service, with effect from the dates from which they were respectively engaged or appointed. It was not open to the High Court to impose such an obligation on the state when the very question before the High Court in the case was whether the employees were entitled to have equal pay for equal work, so-called, and were entitled to have any other benefit. They had also been engaged in the teeth of the direction not to do so. We are therefore of the view that at best the division bench of the High Court should have directed that wages equal to the salary that is being paid to the regular employees be paid to these daily wages employed with effect from the date of its judgment. Hence, that part of the direction of the division bench is modified, and it is directed that these daily wages earners be paid wages equal to the salary at the lowest grade of employees of their cadre in the commercial tax department in government service from the date of the judgment of the division bench of the High Court. Since they are only daily wages, there would be no question of any other allowance being paid to them. The Honorable Supreme Court has also held to the extent that only they will not be allowed to any. In view of our conclusion that the courts are not expected to issue directions for making such persons permanent in service, we set aside that part of the direction of the High Court directing the government to consider their cases for regularization. We also notice that the High Court has not adverted to this aspect as to whether it was a regularization or it was giving permanency. That was not directed by the High Court. In such a situation, the direction in that regard will stand deleted, and the appeals filed by the state would stand allowed to that extent. If sanctioned posts are vacant, they are said to be vacant. The state will take immediate steps for filling those posts by a regular process of selection. But when the regular recruitment is undertaken, the respondents and so and those in the commercial taxes department similarly situated will be allowed to compete waiving the age of restriction imposed for the recruitment and giving some weightage for their having been engaged for the work in the department for a significant period of time. That would be extent of the exercise of power by this court under Article 142 of the Constitution to do justice to them. Now 36.3 also, I'll just be referring to that. We have extracted the aforesaid paragraph so as not to make any inference on our own, but to project the determination rendered by the constitutional bench
That's
as our expressed by the bench. We have no hesitation in concluding that the Constitution bench consciously distinguished the case of pay parity from the issue of absorption regularization. It was held that the issue of pay parity, the High Court ought to have directed that the daily wages workers be paid wages equal to the salary at the lowest grade of their pay. That is what I am harping on. So my respectful submissions for my lord's kind consideration. One document I will
This
again.
is the only paragraph? 56.2?
36.3 and the concluding part, naturally, this was taken into
36.3?
36.2 and 36.3, and now the concluding paragraph, I will be referred to 54.
Yes.
I'm sorry, Let's go ahead.
So you read para 54 also.
I will place the entire expression. The full bench of the High Court, while adjudicating upon the above controversy, had concluded that temporary employees were not entitled to the minimum of the regular pay scale merely for the reason that the activities carried on by the daily wagers and regular employees were similar. The full bench, however, made two exceptions. Temporary employees who fell either in the two exceptions were held entitled to wages at the minimum of the pay scale drawn by the regular employees. The exceptions recorded by the full bench of the High Court in the impugned judgment are extracted hereunder of Tarsing so and so. A daily wager, ad hoc or contractual appointee against the regular sanction post, if appointed after undergoing a selection process based upon fairness and equality of opportunity to all the eligible candidates, shall be entitled to minimum of the regular pay scale from the date of engagement. But if the daily wager, ad hoc or contractual employees are not appointed against a regular sanction post and their services are availed continuously with notional breaks by the state government or its instrumentalities for a sufficient long period for 10 years, such daily wages, ad hoc or contractual appointees shall be entitled to minimum of the regular pay scale without any allowance on the assumption that work are perennial in nature. If perennial nature is available and having worked for such a long period of time, an equitable right is created in such category of person. Their claim for regularization, if any, may have to be considered separately in terms of the legally permissible scheme. In the event a claim is made for minimum pay scale after more than 3 years and 2 months of completion of 10 years of continuous service, a daily wager, ad hoc or contractual employee shall be entitled to arrears for a period of 3 years and 2 months. Now the conclusion. A perusal, that is why I was referring to. A perusal of the above conclusion drawn in the impugned judgment passed by the full bench reveals that the full bench carved out an exception for employees who were appointed against regular sanction posts if their services had remained continuous with notional breaks for a period of 10 years. This category of temporary employees was extended the benefits of wages at the minimum of regular pay scale. In Uma Devi's case number so-and-so, similarly, employees who had rendered 10 years service were granted an exception referred to para so-and-so of the extracted in the above position adopted by the High Court reveals that the High Court intermingled the legal position determined by this court on the subject of regularization of employees while adjudicating upon the proposition of pay parity emerging under the principles of equal pay for equal work. In our view, it is this mix-up which has resulted the High Court recording its above extracted conclusion. The High Court extended different wages to temporary employees by categorizing them on the basis of their length of service. This is clearly in the teeth of judgment in daily rated casual labor case. In the above judgment, this court had the classification of employees based on their length of service, those who had completed 720 days of service in a period. So. Now, 54.3 also. Based on the considerations recorded herein above, the determination in the impugned judgment rendered by the full bench of the High Court whereby it classified temporary employees for differential treatment on the subject of wages is clearly unsustainable and is liable to be set aside. So, in that view of the matter, I am claiming and one thing.
No. You see, para 54, there were two classifications.
Milords, that was there.
One was one,
Milords,
other was two. The
Milords.
entire judgment is dealing with two and not with one.
Milords, this honorable court, Milords, the honorable Supreme Court, by taking into account, Milords, that different, Milords, there cannot be distinction on the basis that you are a daily wager or you are a contractual employee.
You are interpreting the judgment, you are not reading it from the judgment. You see, this particular judgment at para number 54,
Milords,
two categories, two exception was
carved out, Milords, that is
right?
there in Milords
A daily
paragraph 5 of
wager,
the...
ad hoc or contractual.
Milords, that is the crux, Milords, of Tar Singh, Milords, the full bench has been quoted to that extent, Milords. But Milords will appreciate 54.3, Milords, it is clearly to the extent that the classification of the, Milords, 54.3, Milords.
No, you see, this is if a person continues for 10 years.
Milords, I am not onto that part,
No,
Milords.
you have to be on that part.
Milords,
No, because clause 2 and 3 is specifically
Milords,
dealing
I
with
am
10
only
years.
to the extent, Milords, that being a daily wager, Milords, if I am performing the same part of the work, Milords, as has been performed by other persons, Milords, I am also
On the
entitled.
threshold from day 1.
Milords, I am also entitled for the same honorarium, Milords. I am not claiming, this is not a case of parity, Milords, pay scale, Milords, determination. I am not claiming any pay scale, Milords. I am only claiming that with respect to the payment of honorarium, Milords, there has to be parity.
This para 54 within bracket 1
Milords,
has been overruled.
Milords, it has never been overruled, Milords. Para 54.1 has never been.
So
Milords,
therefore,
rather
a
the view
daily
of the
wage,
Milords-
ad hoc or contractual appointee against a regular sanctioned post, your appointment is against a regular sanctioned post. If appointed after undergoing a selection process based upon fairness and equality of opportunity to all eligible candidates, shall be entitled to minimum of the regular pay scale from the date of engagement. So it covers daily wage, ad hoc and contractual.
Milords will appreciate one thing, Milords. Here the case, Milords, although this judgment is, Milords, on the concept of parity, Milords, but Milords, the facts are totally different, Milords. Their pay parity was being claimed, Milords. Here there is no concept of computer operators are not being given a pay scale, Milords.
Because that is, you are arguing your case which is beyond your pleadings also.
Milords, that is what,
You are not claiming, your claim was that as per their circular you are supposed to be paid.
as per their
And in the counter affidavit it has come that you were working as daily wager. Now you are saying that even if you are assumed to be daily wager, so there should be pay parity.
So for
That is
that-
not the tenor of your case. If you want to have pay parity, you will have to file a separate writ application, not in this. That is not your case. In your
Because I am only-
just tell us where is your statement of equal pay for equal work in your
Milords,
entire.
Milords, one thing, Milords, I
No,
will just
show me
mention.
something
Para
from your.
five- para
You see,
five of my pleadings.
we cannot give
Milords,
you
I
a
will not
relief.
go Milords, I cannot go beyond the
Show
pleadings.
us from your petition
Milords,
that you are claiming pay parity.
Milords, para 5 of my Milords, only para 5 may be indicated. Milords, para 5 एक बार जरा सा देख लीजिए, and what reply they have stated in their counter affidavit. Para 5 of my pleadings only. Milords.
Yes.
Milords, I was engaged as a Milords. I have not stated that I was appointed. I was engaged, Milords. It's a kind of engagement only, Milords. Thereafter, Milords, this was the scale at the relevant point of time which was being paid to me, Milords. Thereafter, the government took this decision, Milords, and only one document I will beseech, Milords, and then Milords.
Where is the monthly remuneration of this? 10,580.
Milords, earlier when I joined, Milords, this I was being paid, Milords, and thereafter, Milords, this has been enhanced to 26,000, Milords, which I
When
have
did you
referred to.
join? Because you said that you have joined in 2018,
Milords, 6/5/2018, Milords.
and then this resolution is dated 2/6/2017.
Milords, it took time for implementation, Milords. That document is also on record, page 17. I am
You do
referring.
not get it.
25/10/2019, Milords, it was implemented with respect to the Greek Kara Vibhag also, Milords. And there was a direction to that extent that the department is competent enough to grant and sanction to the computer operators, Milords. That is my respectful submission. Annexure 2 खाली एक बार देख लिया जाता
नहीं,
हूँ.
आपका तो engagement ही 2018 में हुआ है.
That is the reason.
Then, therefore, in the year 2018, you were engaged. You were not given this
No, Milords.
amount of.
Why I was not given, Milords? Annexure 2, page 17 would clarify it, Milords. That is our document of 2019 after my engagement, Milords. And this is by the Milords Joint Secretary, Milords, in relation to this implementation of this, Milords.
What is it? Read it, please.
Milords. निर्देशानुसार उपरोक्त विषय स्वयं झारखंड अंतर्गत कार्यालयों में कंप्यूटर ऑपरेटर एवं डाटा एंट्री ऑपरेटर के पद पर कार्यरत कर्मियों का पारिश्रमिक निर्धारित करने के संबंध में स्पष्ट आदेश देने का अनुरोध किया गया है। इस संबंध में कहना है कि उक्त कर्मियों की नियुक्ति प्राधिकार कार्यालय महानिदेशक है। अतः योजना सह वित्त विभाग स्वयं का पत्रांक 6.2 संकल्प की कंडिका 5 के आलोक में इनकी पारिश्रमिक वृद्धि का निर्णय लेने के लिए भवदीय स्वयं सक्षम है। उक्त संकल्प के पारिश्रमिक के संबंध में स्पष्ट रूप से उल्लेख किया गया है। भवदीय स्तर से कार्रवाई की जाएगी। And thereafter, Milos, page 18, Milos, it Milos turns to the, and thereafter this is the direction issued by the IG prisons, Milos, to the Adhichar for implementation of this, Milos. That is of 10th January 2020, Milos.
Your post is sanctioned,
Milos, the post of a computer operator, Milos. So
not
far,
sanctioned so far. Not even one post is sanctioned.
Milos, in the whole state, Milos, it is working like this on, on a makeshift arrangement, Milos. There cannot be a regular, Milos, appointment to the best of my brain.
What is your date of appointment as per the records?
6/5/2018, Milos.
How many days did you work?
Till
Milos,
2020.
6/5/2018, Milos. I have calculated the entire chart also, Milos,
Two.
in my representations, Milos.
Two?
6/5/2018, Milos, to 16/1/2020. No, Milos, I'm sorry, Milos, I'm sorry. 6/5/2018 to 2/12/2020, Milos. Annexure 4 series, page 19, Milos, I have given the details, Milos.
आपको इनिशियली कितना दिया था?
Milos, I have mentioned, Milos, 10,580, Milos. Even, Milos, if the IG prisons, Milos, is to consider my grievance, Milos, that would be redressed.
आईजी प्रिजन नहीं करेगा तो फाइनेंस डिपार्टमेंट करेगा। हम आईजी प्रिजन के पास भेजेंगे नहीं।
My counter affidavit para 8 and para 13 is important. Firstly, come to para 8, page 5.
Yes.
That with regard to the statement made in paragraph 1 of the writ petition, under reply it is stated and submitted that the same is player of the petition before the honorable court are improper and spurious because he was engaged as only a daily wager and not as a salaried employee during the period mentioned.
Para number? Sorry.
Para
8, Milos.
Para
Page
8 of the
five.
counter affidavit.
Para 8, page 5, Milos.
It's they joined the root.
Para 8, page 5. The honorable court are improper and spurious because he was engaged as only a daily wager and not as a salaried employee during the period mentioned above. He already received his entire daily wages on voucher payment. He is not entitled for any areas as previous. Thereafter, para 30, page 7, which they are relying on the annexure 2 euros. We have replied in this. And that with regard to the statement made in by the petition in paragraph so and so of the writ petition, under reply it is humbly stated and submitted that annexure 1, 2, 3 of the writ petition are related with the revision of salary of the employees according to 7th pay matrix of Jharkhand State Finance Department has issued the resolution number so and so, which is annexure 2, for such employees of the state who have been appointed on contract basis or otherwise appointed as an employee, and accordingly respondent authority issued direction for such employee.
So therefore, he says that he's falling under the category or otherwise appointed as an employee.
Yes, and
Does he
can you
fall
see the
under this
annexure?
category?
Sorry.
Does he fall under this category?
No, Your Lordship, he is the daily wage, and in the last part, Your Lordship, we
Well,
have
what is the meaning of or otherwise employed?
That is there in the Sankalp itself.
संकल्प itself के जो कॉन्ट्रैक्ट बेसिस पे है, जो एम्प्लॉयज है उनको मिलेगा, और उसके अलावा जो कॉन्ट्रैक्ट बेसिस पे उनको मिलेगा।
नहीं, दोनों है।
इससे देखिए अन्य कार्यालयों में एक मुश्त संविदा राशि प्रति संविदा राशि
अन्य कार्यालयों में एक मुश्त
संविदा राशि
एक मुश्त क्या हुआ?
होलसम है।
What is एक मुश्त?
एक मुश्त या
There
संविदा।
is no clarity. What is एक मुश्त?
Sir, what I am suggesting, Your Lordship, this notification was issued stating that कि वित्त विभाग के संकल्प संख्या 965 दिनांक 25/3/2009 द्वारा कंप्यूटर ऑपरेटर के लिए किया गया, and which is we have made annexure at page 16, Your Lordship. Kindly see.
16 में क्या?
Page 16 में before that, you kindly see page 14, the first line, very first line. वित्त विभाग के संकल्प संख्या 965 दिनांक 25/3/2009 द्वारा कंप्यूटर ऑपरेटर डाटा एंट्री ऑपरेटर को मासिक मानदेय के रूप में धारित पद के पूर्ण निश्चित पेमेंट के प्रारंभिक प्रक्रम एवं उक्त वेतनमान वेतन संरचना में इसमें ये अमेंडमेंट आया है। तो ये जो 965 था वो फॉर विच पर्पस था, दैट इज मेड एज एनेक्सर 16। वित्त विभाग परिपत्र संख्या सो दिनांक सो द्वारा संविदा के आधार पर नियुक्ति के संबंध में प्रक्रिया निर्धारित है। Those who have been appointed on the contractual basis, Your Lordship, and we have specifically mentioned at page 9 that petitioner was never not given any appointment letter for the contractual employee. Hence, no right occurred upon him, and he is not entitled for any claim for arrears of salary. We have
No
specifically
appointment
stated.
letter was ever issued to him.
No, Your Lordship. He was engaged, Your Lordship. That is also been mentioned at page 8. But the petitioner was never appointed on any contract as an employee. He was simply a skilled daily wager. He already received his complete calculated daily wages for the period of his engagement in Lower Daga jail on voucher payment basis, and no amount is due on the account of his daily wages. And thereafter, in page 9, the deponent simply submitted that in order to meet day-to-day requirements of jails and further to maintain several works in jail premises, the service of daily wages were being taken and payment were made to them through vouchers. The petitioner was not given any appointment letter, hence no right occurred upon him, and he is not entitled for any claim arrears of salary. This is the specific case, Your Lordship. The annexure 2 which we
I've
have.
heard you. I'll pass the order in the second.
Milords. Only to that extent, Milords, page 10, Milords, of my rejoinder, Milords, that is the letter of joining, letter of Milords submission of my joining, Milords, which has been
Joining
approved by
without
this.
any appointment letter.
Milords, that is there. स्थापना जेल उसको अनुमोदित किया है. That is the endorsement has been made on that.
आपके पास अगर थोड़ा टाइम हो तो एक छोटा सा आधा
हम
पन्ना
तुरंत
4 लाइन का बना के
अभी
दीजिएगा।
सेकंड हाफ
हाँ सेकंड आप भी दे दीजिएगा, ऑर्डर लिखाने में सुनता
हाँ relevant paragraphs also of the
I
judge.
just हाँ you are relying upon para 6 36.2 36.3 54
Milords, one Milords else Milords
वो जल्दी वापस मत करिए।
अभी नहीं उसमें paragraph 44 is also the concluding part Milords. 44 that is the
concluding
most
part of
44 is the Milords parameters on which it can be done Milords, but that is in relation to a different aspect, but Milords will derive some Milords the jurisprudential thoughts Milords from it.
And the judgment which he has referred, Your Lordship, though I have not gone through, but what
They-
I have learned, Your Lordship, that is for the purpose of regularization. If he has worked for 10
No, it is Jagjeet Singh is
We'll
not
judge.
at all with this purpose.
we'll see that।
It is not at all for the purposes of regularization. It is only for the purposes of fixation of the lowest pay scale. And that has been followed by the division bench of this honorable court Milords with respect to a person who has been whose appointment has been found to be illegal Milords, not irregular Milords. I am using the word illegal Milords.
Item 7 WPS 2090 of 2023.
In this case, I have to file rejoinder. This honorable court directed them to file counter by 7th and rejoinder by 14th. They filed counter on 14th.
Counter is not in the requirements.
counter is not on record.
The counter is ready, my lord.
No, you were to respond as to whether you have an alternative remedy. Do they have an alternative remedy?
No,
Thereafter, being satisfied, your ladyship directed them to file counter. After this, no alternative remedy is there.
Okay. You have filed your counter?
my lord, the counter is ready, my lord.
WPS number 2090 of 2023. Counsel for the parties are present. Counter affidavit. You are filing it now?
Yes.
Counter affidavit filed during the court proceedings is taken on record. The rejoinder, if any, be filed by 4th of April. Post this case under the heading for final disposal on 24th April.
One more prayer. They will be directed to file inquiry report.
You have not been granted inquiry report.
No,
Where have you stated?
no, I have not stated that. But
We will not ask it. When you have not stated, you should have filed it. You responded to the second show cause.
second,
You responded.
yes,
It was for your duty to bring it on record. Why should they bring everything on record?
that was not served. Inquiry report.
Have you stated in
No,
your
I have not.
not so? ऐसा थोड़ी होता है.
Item 8 WPS 4534 of 2023.
Already in this matter, main respondent is the Union of India, my lord, and after the direction of 22 February 24, my lord, counter affidavit has not been filed by the Union of India. Because my lord, after the retirement, the post of the petitioner has been changed and the pension has been reduced in this matter.
Pension has been reduced.
Yes,
So it is an admitted fact that the pension was reduced.
yes, my lord.
So therefore they have revised the pension. You just
No.
read the judgment.
No, my lord. Only, my lord, in this matter, after the retirement, the post of the petitioner has been changed. Because the pension petitioner was getting the pension from the post of honorably captain. Now that post has been, my lord, changed. Honorably lieutenant, without giving any notice, my lord. After
What is your case? You were working as lieutenant or you were working as captain?
captain?
Where
petitioner-
have you stated?
Yes, my lord.
Where have you stated your designation?
Yes, I have mentioned, my lord.
Mentioned. बताइए कहाँ? In your writ petition, from which post and under which capacity
Yes, my lord.
were you working last? Writ
Yes, yes, my
petition में
lord.
दिखाई
Yes, my
दी.
lord. Kindly see, my lord, annexure 1, my lord.
Annexure not from the annexure. Your writ petition.
Yes.
What was your last posting and in which capacity were you working?
Yes, my lord. I have mentioned, my lord, annexure paragraph 7, my lord,
Parasite.
page 9.
Yes.
That it is stated that the had the corrigendum PPO number, my lord, 99th army dated Idna, being original PPO number 97, it appears that the petitioner superannuated date of discharge on Itna from the post of Subdar Major Honorable Lieutenant, and the last basic pay was drawn Itna. Annexure 2, lord.
Okay. What they have done? You just see para 6 also. The petitioner was held ranked last sub major
Yes, my lord.
and his last basic pay was 2240.
Yes, my lord.
So,
my
what
lord,
they have done now?
So, my lord, I will
So according to you, they have withdrawn this amount.
My lord, the petitioner was retired from the post of my lord last Subedar Major. After that, made the scale of the petitioner was given to honorably captain.
From where do you say that you retired as a captain?
No, I am not. I petitioner retired from the post of Subedar Major.
Yes.
After that, the basic scale of the pension of the petitioner was given to the petitioner honorably captain. That was changed.
From where do you say that the basic pay was revised and you were given the pay scale of captain? From where do you say this? That your basic pay was revised?
Yes, my lord. Paragraph 8.
Yes.
that it is pertinent to mention here that the VAT corrigendum PPO number dated 21 August 2012 in respect of the last rank held by the petitioner was Subedar Major Honorary Captain. And revised basic scale of pay of rupees 13,850 to 13,850 with effect from 2006.
But you never worked as honorary captain, did you?
उनको स्केल दिया गया था आफ्टर पिटिशनर रिटायर हुए हैं सूबेदार मेजर के पोस्ट से
स्केल बाद में कैसे दिया जाता है?
जो है वो जो इसीलिए तो बोल रहे हैं कि उनका काउंटर इसमें जरूरी है यूनियन ऑफ इंडिया का
Your Lordship, in this case, the judge has to argue in this case, Your Lordship. So pass over for few cases, Your Lordship.
You don't want to file a counter affidavit.
No, no. The counter is needed in this case, Your Lordship.
Then you file a counter.
Yes, Your Lordship. Then allow.
If there is an error committed by you,
Yes.
then pension can certainly be revised. The point which will fall for consideration is whether the revision of pay scale was done at all or not, or it was just an error on your part.
Yes.
Because his specific case is that he worked as sub-major and then he superannuated as sub-major honorary lieutenant. Right? It is not his case as that he retired as a captain.
Yes, Your Lordship. I will file the counter affidavit. Your
Learned
Lordship.
counsel for the parties are present. While giving the foundational background of the case, the learned counsel for the petitioner has referred to paragraph 6 and 7 of the petition to submit that the petitioner was held rank last sub-major
सब मेजर
and his last basic pay drawn was rupees 2240, and he superannuated on 28/2/1998 from the post of sub-major HONY, LT dot within bracket lieutenant bracket close, and last basic pay drawn as rupees 2240 read 10,500. इसको quotation में डाल दीजिएगा इस paragraph से. It is his further case that a corrigendum dated 21/8/2012 was issued in respect of last rank held by petitioner and it was mentioned as Subedar MAJ HONY captain, and the basic pay scale was revised to 13,850 with effect from 1/1/2006, and ultimately the petitioner was drawing pension in terms of the corrigendum PPO, right?
Your Lordship, but before that, kindly see Annexure 2, Your Lordship.
We'll see that. You file your contract.
Yes, yes.
The learned counsel for the respondent Union of India has submitted that if there has been any error on the part of the respondent Union of India with respect to the pay scale or the designation of the petitioner, then they have a right to rectify the same. However, no counter affidavit as such has been filed. यही आपका केस?
Yes, Your Lordship, but Annexure 2, from Annexure 2 it appears that for column rank for pension sub-major read as Honorable Lieutenant. So notice has been, there is knowledge in the petitioner that his rank converted in lieutenant. Your Lordship.
The learned counsel has submitted that the petitioner has due knowledge
Yes,
that
Your
is about his actual rank as lieutenant,
Yes.
and therefore he cannot take any advantage of any error committed by the respondents, even if PPO has been issued showing him as captain. यही तो PPO as captain issue किए हैं ना आप इनको?
हाँ तो annexure 2 भी PPO का
Let the
ही
counter affidavit of the Union of India be, how much time do you need to file counter?
Your Lordship, there is some process, so 6 weeks may be done, given Your Lordship.
Be filed by 30th April.
Yes, Your Lordship.
Rejoinder if any by 7th May. हो जाएगा rejoinder? Post on 8th of May under the heading for final disposal.
Item 9 WPS 6978 of 2023.
Lordship, on last occasion, Lordship directed to file specific counter affidavit. Despite that, I have not done Lordship, so kindly give me to
WPS number 6978 of 2023. Counsel for the parties are present. That learned counsel appearing on behalf of JPSC prays for and is granted time till third of April 24 to comply with the order dated 29 to 2024. Post this case on 8th of April.
Item 10 WPS 7162 of 2023.
Yes, petitioner.
In this case, given to Jharkhand to bring on record the report of the export election.
They have brought us over.
Report is there, also they have brought, but as the file has been listed on 15th only, leadership, and so the counter was given to the state, but not to be served, was not being served, was being started in.
You want to file it right now?
Yeah. Even the original file is there, leadership, you can also.
Have you given it to?
No, leadership.
You have given it to the state. इसमें भी तो receiving कराइए ना?
हाँ, correct.
कराइए.
Your Lordship, I am not the standing counsel in this case.
Who's your senior? Where is your counsel?
Your Lordship is on the way.
Okay, you receive it. We'll post it at 2:15. You come at 2:15, right? वो दे दीजिए काउंटर.
Under heading for orders with defect, item 11 WPS 1796 of 2023.
It is still defective. There are so many defects.
No,
defects in my humble submission, we have filed one IE petition for deleting the prayer
That's
at para 1, Roman 1.
so that has already been taken care of.
No, but on the last day, my lords have passed order. Kindly peruse the order which my lords have passed.
Yes.
I am placing for the kind position. Counter affidavit is filed on behalf of in the present case, stating that the revision against the said order has been dismissed, but neither the copy of the memo of revision nor the order of revision has been annexed by the respondent in the court. The learned counsel for the respondent is directed to take instruction and file supplementary counter affidavit. In the present case, annexing the memo of revision as well as the order passed by the revision authority, the needful be done by 15th March 2024. Post on 18th March. Now kindly see the supplementary counter affidavit, what they have stated in the
No,
supplementary
your
counter.
petition is a defective petition. We assume that that was the court fees was the only defect to be removed. There are so many defects.
We have removed all the defects except we
Except,
have removed the defects in my humble submission.
Yes.
Kar diya na? We have removed the defects.
then I will just refer it to the registry to have a fresh stamp reporting. We do not know.
May I pray one thing? On the last day, my lords have heard and lordship had directed the state council to file supplementary counter affidavit with regard to the statements made at para 23 of the counter
Should we ignore the other defects? Ignore का तो कोई order नहीं है. You remove the defects.
We have filed IA petition for ignoring the defect.
Which defect is to be ignored according to the IA?
Defect 2 and 5 1. 2 and 5.
2 and 5 is regarding what?
हैं? जो हम लोगों ने प्रेयर कर दिया था कि रिवीजन फाइल किया था वहाँ पर डिसमिस
सर आप बिना रिकॉर्ड देखे आप बोल रहे हैं आप थोड़ा रिकॉर्ड देख लीजिए पास ओवर कर रहे हैं 5 मिनट के लिए आप इसको रिकॉर्ड देखिए आपका पिटीशन डिफेक्टिव है डिफेक्टिव पिटीशन में हम ऑर्डर्स नहीं कर सकते यू हैव फाइल्ड योर काउंटर एफिडेविट
काउंटर हैज बीन फाइल्ड सीकिंग अपॉलॉजी रिवीजन पिटीशन के बारे में जो लिखा गया था कि वो डिसमिस हो गया है रिस्पोंडेंट ने भी वेरीफाई किया है और बोला है कि हम लोग इनएडिक्वेटली उसको लिख दिए फाइल कर दिए इसके लिए अलग से एफिडेविट फाइल किया गया
कितना कॉस्ट हम दें इसके लिए कितना कॉस्ट इंपोज करेंगे हाउ मच ऑफ कॉस्ट इज टू बी इंपोज बस यही सोच के आप फाइल करिए एफिडेविट
फाइल
आप फाइल कर दिए उनको कॉपी दिए आपको कॉपी दिए हैं ये
कॉपी दिया उसी को देख कर हम बोल रहे हैं
नहीं तो ये बाकी डिफेक्ट का क्या होगा
बाकी डिफेक्ट है जो मेडिकल का प्रिस्क्रिप्शन था जिसके बारे में लास्ट डेट
इग्नोर कर दिए क्या
जी जी उसको इग्नोर कर दिया गया है और दूसरा डिफेक्ट
वो इग्नोर नहीं हुआ है सर हम लास्ट डेट में नहीं इग्नोर किए थे
लास्ट डेट में कहा गया था कि फाइल करते हैं तब हम उस पर ऑर्डर पास करेंगे तो ये ऑर्डर फाइल कर दिए
नहीं
हैं
आप पहले डिफेक्ट हुए वो आप फाइल कर दिए बहुत अच्छी बात है लेकिन आप डिफेक्ट इसको रिमूव कर बिना डिफेक्टिव पिटीशन में हम लोग ऑर्डर नहीं कर सकते
जो मेडिकल का जो डॉक्यूमेंट है उसके बारे में हमारा सबमिशन था तो लास्ट डेट में
नहीं लास्ट डेट में सबमिशन सुने थे ना आपका
जी जी
अलाउ नहीं किए थे ना आप रिमूव करिए डिफेक्ट्स
नहीं वो तो टाइप कराने के लिए कर नहीं रहा है कोई टाइप इसका डॉक्टर का जो प्रिस्क्रिप्शन है ना उसको दिक्कत हो रहा है
तो कैसे पता चलेगा आपको क्या बीमारी
last
था और क्या क्या दवाई लिखा था सर उसके लिए भी आपको पिटीशन फाइल करना पड़ेगा हम ऐसे नहीं इग्नोर कर सकते
आइए फाइल करते हैं उसको इग्नोर कर देंगे
उसके लिए नहीं फाइल की
उसको कर देते हैं कर देते हैं
उसके बाद ही ऑर्डर करेंगे इसको WPS number 1796 of 2023 counsel for the petitioner the counsel for the parties are present at the prayer made by the petitioner post this case on 3rd April
3-5 के लिए आ गया है सिर्फ 2 के लिए करना है
आप देख लीजिए आप अपना वेरीफाई कर लीजिए रजिस्ट्री से समझ लीजिए और जो आपको फाइल करना है
ठीक
डिफेक्टिव पिटीशन में ऑर्डर पास करना मुश्किल होता है
तो नेक्स्ट वीक में रख दिया जाए
नेक्स्ट वीक छुट्टी के बाद रखें 3 तारीख को
बोली तो ठीक है
3 तारीख को रखें
3 तारीख ठीक
Under heading for orders, I come to WPS 2902 of 2023.
In this case, I was directed to file an IA for impeding those persons who would be affected in the gradation issues. However, during the pendency of the writ petition, the respondents has redressed my grievances, and I have filed a supplementary affidavit bringing on to record the gradation list in which my name has been properly placed. That is the on record.
WPS number 2902 of 2023. The learned counsel for the petitioner submits that during the pendency of this case, that grievance of the petition has been redressed, and therefore he does not want to pursue this writ petition anymore.
That be only matter was
And seeks
Grievance
permission
has
to
been redressed,
withdraw
and
this.
the office order has also been brought on record by way of
The learned counsel for the respondents have no objection to the prayer made. Accordingly, this writ petition is dismissed.
I am only indicating that the office order which I have brought on record by way of
कुछ भी बोले dismiss as withdrawn है, sign कर लीजिए and be happy with this. आपका submission हम लिखा ही
Because if the petitions are being filed with the documents and proper resolutions, because I am seeing that some of the grievances are being taken.
हो ही जाता है क्योंकि वो लोग अपना देखते हैं ना record. They don't have any personal against anybody. ऐसा assume करते हैं.
Naturally.
Under heading for fresh filing, item 13 WPS 296 of 2023.
Yes, petitioner. Yes.
Well, this is against the order of transfer of the whole petitioners. That the
Counter आ गया है.
Yes, sir.
Counter आ गया
आ
है.
गया है. Actually, counter is also the same. This is which speaks about my case. What happened when the petitioners were transferred from one school to another in the light of government decision. Thereafter, that decision.
This page number 19 has been annexed in your counter affidavit.
No, Lordship, it is on the date petition. But on last date, Lordship, order.
Page number 19.
That has been
There was a specific order.
Yes, Lordship. We have written letters, but we have not received those orders yet, Lordship. I have written letter on Lordship 11/2024.
Which has been mentioned in page number 19.
Yes, Lordship.
क्यों नहीं आप उसको कंप्लाई करिए ऐसा थोड़ी होगा.
Lordship, I have written letter, even telephonic conversation we have, but we have not received it yet.
So who is the person? We'll ask him to come, no?
Lordship,
He will come and explain if you are not able to.
no, Lordship.
आपकी बात नहीं सुनते ना वो.
PSC Lohardaga has been transferred now, and no,
आपकी बात कौन नहीं सुनता है?
Lordship, I will again.
हम तो कोशिश करेंगे कि हमारी बात सुन लें.
होली के बाद रख दीजिए, हम दोनों letters को record लेंगे.
Actually, in Excel 4, in the case of the petitioners also covered by Excel 4, that is the order of this honorable court.
The case is that, Lordship, that the transfer which has been made was not in consonance with the transfer rules, and that's why that transfer has been cancelled.
So it is covered.
No, not covered.
Yes, absolutely covered. That has been cancelled. And since they have joined the transferred place, the honorable court says that since they have been transferred, they are working there, so their transfer order cannot be cancelled. But contrary to that order, again the petitioner has been transferred. Referring to the order.
WPS number 296 of 2023. Counsel for the parties are present. Counsel for the respondents pray for and is granted time till 4th of March. 4th of April 24 to comply with the order dated 26/2/2024. He has submitted that in spite of repeated contacts, the documents have not been provided to the petitioner. किससे बात कर रहे थे?
Lordship, letter has been sent on 11/3/2024. 11th March.
26 का ऑर्डर था तो 11th को क्यों भेजा?
Lordship, that was mistake on our part, but last date on 11th of March it has been taken up.
11 4 तारीख को कर दीजिएगा.
हाँ कर.
नहीं करिएगा तो somebody will have to appear personally on the very next day. Polls this case on 8th of April. Under the same.
Item 14 WPS 1646 of 2023.
The release by claim for a stock parcel in this matter. This will be argued by my senior in this currently on.
In the relation, I am happy for the bank. If an punishment matter counter will be required in this matter.
All remedies exhausted.
That is the
Have
The
they?
relationship would come to page number 80.
Yes.
Point number 6. If you desire, you may prefer an appeal against the order within 45 days of the date of receipt of this order. The appeal shall be addressed to the chairman and the appellate
Just a
authority.
moment. It's not the same page number.
page
Page number
82.
82.
Point 6.
Yes. You have not
As
preferred appeal.
per the rule, the petitioner was an officer of the bank, and the competent authority for the petitioner is the chairman itself. So the order passed is by not a competent authority. Therefore, we have not been. Therefore, we have not gone in the appeal. As per Rule 2L on page number 88, there is a definition of officer. Officer means an officer of the bank as classified under clause A of sub-regulation 1 of regulation 3, which is on page 89.
Where do you explain it in your writ petition? You just can't straight away go there and start arguing. What is your case? Have you stated that this is the reason you don't want to prefer
In
appeal?
para number 17, page number 13 of the petition.
Read it, please.
That it is stated that after passing the impugned order/penalty order 28/3/2019, the petitioner has not preferred any appeal, as because the impugned order dated 28/3/2019 has been passed by authority who is not competent to pass any penalty order in respect of the petitioner, as petitioner is an officer as per definition of regulation 2(1)L of the Jharkhand Gramin Bank Officers Employed Service Regulation 2010, and further taking into consideration the fact that as per regulation 2(1) subclause G of the Jharkhand Gramin Bank Officers and Employees Service Regulation 2010, the competent authority in respect of the officer of Jharkhand Gramin Bank is the chairman of the Jharkhand Gramin Bank and not the general manager of the Jharkhand Gramin Bank.
So you are questioning the authority who has passed the order of penalty.
Yes, please.
He is the same authority who is the disciplinary authority and initiated the proceedings, or not?
As per the order passed, they are saying that an appeal will lie before the
Who
chairman.
initiated your departmental proceeding?
General manager.
General manager. So he was competent to initiate the proceedings.
As per definition, that competent authority means chairman in respect of officer.
So initiation of departmental proceeding was incorrect,
Yes.
right? Was it your case? You see, the chairman can also examine this, because these things are required to be gone into. What was your status? Who was the competent authority? Because you participated in the disciplinary proceedings initiated by the general manager. You had no objection to that. And then when they say that the appellate authority is such and such person, you say that the order is without jurisdiction. This is what you are saying. Chairman will look into it. He will see the service rules. We will ask him to do it. Because all service rules are required to be seen, your appointment letter and everything is required to be seen.
The matter may be kindly passed over to the justice.
Who will argue?
Mr. Rajan.
Item 15 WPS 3575 of 2023.
What is the prayer?
What is the key difference of the salary with annual increment between the post of executive engineer and assistant engineer for the period 2004 till 2014 with 10% per annum.
Have you represented him for anybody? No representation has been filed and you are seeking a mandamus from this court straight away. You have not sought, you have not approached them. Call him please. Mr. Sani, you are seeking a mandamus without approaching them. You approach them. किसके पास जाना है खाली बता दो.
This is a case not which has been settled by this court.
I have seen your.
So only that would have been my prayer also. Not what came from your mercy. I decided I have formed an opinion that I will seek to approach the response number 2. Response number 2 is the higher authority.
Learned counsel for the parties are present.
But only one thing, not in the light of, I will also supported by the documents along with the judgments of the Supreme Court up to Supreme Court.
We'll take it. This the counsel for the parties are present. This petition has been filed for the following relief. It is the case of the petitioner that the petitioner is entitled for higher pay scale in view of judgment dated 3/9/2021 passed in WPS number 6618 of 2013, which was affirmed by an order dated 4/8/2022 passed in LPA number 79 of 2022 and by an order dated 24/2/2023 passed in SNP number 3367 of 2022.
637.
Sorry, 33637.
Yes.
पैरा 20 में. आप इसमें petitioner थे?
जी नहीं उसमें पानेसर रविदास.
Okay. Yeah, it has been submitted by the petitioner that similarly situated person had filed the aforesaid writ petition being WPS number 6618 of 2013 and the petitioner is claiming similar relief. However, from the records of this case, the aforesaid orders passed by this court has not been filed along with this writ petition. And further, the petitioner has simply claimed that the case of the petitioner is squarely covered, but the petitioner has never approached the respondents for redressal of his grievance, and therefore this court is not inclined to issue mandamus as prayed for by the petitioner in this writ petition. However, the petitioner may approach respondent number 2 for the redressal of his grievances with all the supporting documents, which
including judgments.
Right, which all the supporting documents and pursuant to any such representation, the respondent number 2 shall consider the grievance of the petitioner and pass appropriate orders.
Only one thing, but
within 1 month from the date of the representation.
Item 16 WPS 6982 of 2023.
An advertisement was published by Rings for appointment of 4 paid employees. The petitioners have applied for the same. They have also been selected, but they have not been appointed. Since 2022, the respondent number 3 Rings is sitting tight over the matter. They are not doing anything.
Yes.
My Lord, I'm appearing for respondent number 3. I need time for filing counter affidavit. I have to take instructions from the client.
This matter is pending since 7/12/2023. What are you doing?
My Lord, I have got to take instructions from the client, but there is so much delay. I'm engaged by the senior just
Advance copies are being given to you for what purpose? That you will sit with that. Every respondent is granted 2 copies of the petition. For what? That you will keep it in your chamber. It's such a simple thing. That why the results are not being declared.
Please grant us time, like will reply file see.
You were successful.
Yes, Your Lordship.
Where have you stated that you were successful?
RI8 Ladies. That it is only statement submitted to the respondent.
Learned counsel for the parties are present. Counsel for the petitioner submits that the petitioner had participated in the selection process and was successful, but no appointment letter has been issued to the petitioners, and consequently the present petition has been filed. Have you represented before anybody? Counsel for the respondent number 3. Mr. A.K. Singh appears. Is directed to seek instructions and file a short counter affidavit as to why the appointment letters have not been issued to the petitioners so far. Let the counter affidavit be filed by, and if required, a further counter affidavit will be called for. Right? एकदम short 2 पन्ना का affidavit file कर दीजिए. Let such a counter affidavit be filed by Friday, post on next Monday. वीक ही खत्म हो जाएगा. फ्राइडे तक फाइल कर दीजिए, 1 तारीख को रहे, 1 अप्रैल को.
Item 17 WPL 407 of 2024.
Yes, petitioner.
Section 8 is under challenge, and apart from that, the entire proceeding under the Minimum Wages Act is also under challenge. In this case, on the ground of jurisdiction, which the workers who claim to be employees of this petitioner Elsamex, which the arrangement is that there is the maintenance of road, a special purpose vehicle government company is formed which issues tenders. I am given the tender for maintenance. They have filed a claim under minimum.
Mr. Singh, why the result has not been, ultimately appointment letters have not been issued? It is very strange. I have asked you to file a short counter affidavit by Friday only to this effect. If required, we will call for further counter affidavit.
Hridaya Pandey is serial 16.
I don't know. Yes, serial 16. Right, you just file a short counter affidavit as to why the result, why they have not been issued appointment letter. Maybe that there are some more nuances to that.
Why appointment letters
have not been issued?
Not
Yes, continue.
They have filed a case against Elsamex as well as the other companies.
You can't agitate this point before the authority.
Look, we have raised a jurisdictional issue again that they have claimed that for the period 2012 to 2021, they have not been paid overtime wages, and they are now claiming that for the entire period of 10 years, each day they have worked for 4 hours. All the workers have worked for 4 hours extra, and they are entitled to be paid overtime wages. Now, this is not maintainable under the Minimum Wages Act. Section 14 and Section 20 may be seen. It is only a dispute in relation to the rate of overtime wages. Section 14 clearly says under different enactments there are different rates at which overtime wages have to be paid. This is a simpliciter case of non-payment of overtime wages, for which they have to file a case under the Payment of Wages Act. In para 10, I have said that they have also filed under the Payment of Wages Act. One of their cases has been dismissed. They have filed 4 other cases. They are bringing about multiplicity. And this aspect has not been considered, that how can a claim of non-payment be decided. It is squarely covered by a decision of the
Where is the notice?
Lordship. The claim is there, Lordship.
Where is the claim?
Claim is annexure.
They must
1.
have issued the notice to you.
Lordship, the claim
The
has
respondents must have issued notice to you.
Lordship,
Unless the notice is issued, it is premature.
no, Lordship, he has even condoned the delay.
Where is that?
That order is also impugned annexure, that is annexure 8. The claim is annexure 1. So they are. I have also filed a supplementary affidavit, which is a subsequent development in which they have filed another case in labor court also. So substantially same relief, in which evidence has also been recorded. That evidence also I am bringing. So they are abusing the process of law. They are saddling the company with multiple cases, and it is a purely false case saying that for 10 years everybody worked 4 hours overtime and they have created a demand of 17 crores with 10 times compensation. So the entire process is to, this amounts to extorting the company. The company will be unable to work if this kind of claim is entertained.
Where is the
Multiple
claim?
claims are being
Where
filed.
is the claim? And where is the order for condonation, for seeking
So
condonation?
annexure 1 is the claim. Page 29. Para 5 also they are saying that I am not paying wages. Wages is being paid by Shiva Protection Private Limited and Quality Engineer Traders. But they are saying that they are sham, they are only giving wages. Liability is this petitioner Elsa makes and the Jharkhand Accelerated Road, which is the special purpose vehicle found by the government for maintenance of roads. They are saying that is the principal employee, you are the contractor, these 2 persons are sham, but admittedly they are being paid by these 2 organizations, not by me, which they themselves admit. And then they have issued a claim at page 34 in which they have not mentioned period. Total 1 crore 55 lakh. This is their total claim. And not only that, in annexure 3, I have also brought another document. Out of these 32 workers, 16 have sworn affidavits that our signatures are forged. And still he is proceeding ahead with this case, the authority. And he is asking me, you examine those workers, though I have annexed their affidavits also at annexure 3, saying that our signatures are being forged by
Yes,
the
madam,
union.
respondent.
Yes, I'm appearing on behalf.
You serve all the respondent number 3 to
3 to
34.
3
3 to 34.
and 35, 36, 37 they may also be noticed.
No, they may be noticed, but so far as 3 to 34 is concerned,
So the
they
next
are before you, before the assistant labor commissioner.
They are before
You
this.
serve all of them. They will not take separate notices.
In
to
fact,
all.
my instruction is that the date is 3rd April next date. I can supply copies on that day before the ALC.
Right, you serve all of them. File your affidavit regarding service of notice also. Right, you provide them at least 10 copies.
And provide.
There are multiple proceedings going on. They are, as they have stated, we do not know. So, and in the meantime, don't proceed. Right? The learned counsel for the petitioner and respondent number 1 and 2 are present. The learned counsel for the petitioner has submitted that multiple proceedings have been initiated by the private respondents. That is respondent number 3 to 34.
All through Binod Singh. He is the first.
All through
Binod Kumar Singh.
respondent number 3.
Paragraph 10 I have given the case now, other case numbers. also.
And the details of the cases have been mentioned in paragraph number 10. the learned counsel has submitted that the proceedings before the respondent number 2 is not maintainable. Give me one ground. Striking
The jurisdictional ground is that the claim for non-payment of overtime wages can only be adjudicated under Payment of Wages Act, not under the minimum.
And the learned counsel
Only when there is a
submits-
rate dispute it can be under the minimum.
The learned counsel submits that the non-payment of overtime wages cannot be adjudicated under the provisions of Minimum Wages Act. The same is required to be adjudicated only under the provisions of Payment of Wages Act. The learned counsel has further submitted that as per the claim petition itself, the payment was being made by the private respondents number 35 and 36, right? Is that
35,
correct? 35 and 36. Quality engineers and
They were paid by 35 and 36.
35 and 36.
And
Who is
37 is
31 is the?
37 is the government special purpose vehicle.
Okay, and respondent number 37 is the special purpose vehicle to carry out the repair work of the road, of the roads in Jharkhand. Of the roads in Jharkhand.
Jharkhand Accelerated Road Development Company Limited.
Okay. Issue notice to the respondent number 3 to 34 through the respondent number 2, before whom the proceeding has been initiated. The requisites for service of notice सभी का फाइल कर दीजिए. They are individually appearing or through respond number?
They are appearing through, in the claim they have mentioned Binod Singh and annexure they have mentioned.
Okay.
Annexure 1 करके दे दिया. So otherwise I may be directed to straight away go and serve on the next date fixed
Okay.
in before the ALC.
Okay. And
on all of them I
just a
will serve
moment, just
through
a
ALC.
moment, just a moment.
जैसे MW केस नंबर 13-21 में proceeding चल रहा है.
Just a moment. The requisite, it has been you file all the copies before this court. Otherwise, ये ना कहानी खत्म नहीं.
हाँ, नहीं I'm fine.
The requisites for service of notice upon respondent number 3 to 34 be filed before this court by Friday. नहीं, by Friday कैसे होगा? Third को date है ना? By Thursday. By Thursday. By Thursday. And the petitioner may provide the copies of the notice to the respondent number 2 latest by 2nd of April. And the respondent number 2 would ensure that the notices are duly served upon the respondent number 3 to 34 who are appearing before the state authority. The respondent number and the service of notice should be accompanied with a copy of the Aadhaar card of the concerned respondents. Let the affidavit regarding service of notice be filed by respondent number 2 or his authorized representative before this court by 30th April. By 30th April, let
5 to
notice.
37 का भी कर दें.
हाँ हम करा देते हैं
35 to
हाँ
37.
like notice we also issued through registered through speed post as well as ordinary process upon respondent number 35 to 37 for which the requisites we filed by this Thursday. Post this case on 1st of May. Till 1st of May, further proceedings before the respondent number 3 is directed to be stayed, shall remain stayed. In connection with MW case number 13 of 21. The respondent number 2 shall also file counter affidavit prior to the next date of hearing. Affidavit of service fee आपको file करना है, counter affidavit भी file करना है.
Passover case, item 3, WPS 364 of 2023.
Madam Pinky Tiwari was there. Where is she? आने दीजिए. Call.
Passover case, item 14, WPS 1646 of 2023.
This is an appealable order.
My lords,
Is this an appealable order?
my lords, appeal against because the by appointing authority, disciplinary authority, my lords, is the chairman,
Who initiated the disciplinary proceedings against him?
general manager. Charge sheet has been issued by the general manager, an extra 5-page 40.
You objected to his authority at any point of time?
Lords, actually petitioner has accepted the guilt and the punishment has been imposed.
But still,
So-
that will not confer jurisdiction.
Lords, yes. So we have not confronted, at the relevant time, he has not confronted whether the authority is competent or not. Only my submission is, Lords, that if the authority is incompetent, then any order passed is a nullity.
We appreciate that, but this aspect can be considered by the chairman also.
Yes, Lords.
So you go there.
Lords, then in that case, Lord, the order which has been passed, the punishment order which has been passed,
He will consider it. He will consider this aspect in appeal. Whether this particular person could have issued you the
unless your
proceedings.
lordship- I agree.
I will
Unless-
observe that.
Unless your lordship directs, because he cannot entertain an appeal being the appointing authority.
No, you see, it is one thing. The appointing authority in this case never initiated a proceeding
Never
against you.
initiated.
So therefore, once he comes to know that an authority subordinate has initiated, he will take
But
care
can
of
remand
that.
it, can remand it, Lords, to that.
Right?
I don't have
You
any problem.
prefer your appeal,
Yes,
and I
yes.
will ask you to raise all these jurisdictional
My
issues.
My
You consider it.
My lords.
Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner, by referring to the point involved in this case, has submitted that the memorandum of charge was issued against the petitioner by the general manager, stating to be the competent authority, and an order of punishment has also been passed by the said authority. He submits that although the point of jurisdiction has not been raised in the disciplinary proceedings, but the general manager was not the competent authority to initiate a departmental proceeding against him, and therefore the entire proceeding is vitiated on account of want of jurisdiction. The learned counsel submits that the appropriate authority would have been the chairman himself, and therefore the present writ petition has been filed in spite of the fact that the impugned order itself reflects that the petitioner may file his appeal before the chairman, being the appellate authority. The learned counsel, appearing on behalf of the respondents, has submitted that if the proceeding has been initiated by an incompetent authority, this aspect of the matter can certainly be taken care of by the chairman, and therefore the present writ petition may not be entertained. He has also submitted that the various circulars and the rules governing the petitioner will have to be taken into consideration, and therefore the present proceedings may not be a proceedings on pure question of law. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that a point of jurisdiction has been raised by the petitioner, but at any point of time the petitioner did not raise the point of jurisdiction before the authority who had initiated the disciplinary proceedings, but at the same time merely participation by the petitioner will not confer jurisdiction on the said authority. However, so far as the point of jurisdiction is concerned, it appears to be a mixed question of fact and law in the present case, and accordingly this court is not inclined to proceed any further in this writ petition, leaving it open to the petitioner to agitate this point before the chairman and the appellate authority.
Respondent number 3 notes.
That is respondent number 3, as the impugned order itself indicates that the appeal would lie before the chairman and the appellate authority. This court is of the considered view that if the petitioner files an appeal before the chairman and the appellate authority within a period of 1 month from today and raises the point of jurisdiction, the point of jurisdiction shall also be taken care of by the chairman and the appellate authority by deciding the case on merits as well. Both the point of jurisdiction as well as on merits be decided by the respondent number 3. That's it. This petition is disposed of.
Time frame may be given.
Time frame अभी तो फाइल ही नहीं किया.
Within a week I will file it. Filing at least after filing minutes within whatever your lordship thinks. Otherwise
I have given you time one month.
minutes.
आप कर दीजिए हो
आप कर देंगे. नहीं हुजूर नहीं टाइम लोग क्या होता है ना फिर पेंडिंग रह जाता है. He person has already retired minutes. So if something he is
if the appeal is filed, the respondent within the aforesaid time frame, the respondent number 3 shall ensure expeditious disposal of the appeal, preferably within a period of 3 months from the date of filing the appeal.
Actually, in the Miller's rules, the appellate authority is the board. If the officer is there, the appointing authority is the chairman, appointing and disciplinary authority, and the appellate authority is the board. For the employees, Miller's.
If the entire proceeding is vitiated, then they will have to take a call whether
Yes,
they do not know.
Yes.
Whether they still want to proceed or since you have retired, whether they can proceed, not proceed.
Yes.
So these things, there are so many nuances to this.
Oh, chairman will take care of it.
He will take care of everything. That's
Item 3 pass over. Item 3.
Is it on the same set of facts?
Same set of facts, Your Ladyship. Based on the information for the, accordingly, the departmental proceeding was taken up and he was dismissed.
And criminal case was also instituted simultaneously.
Yes, Your Ladyship. Annexure A, the Aropa Patra we have already annexed. The charge was free. Serial 3.
Annexure A.
A. Yes, Your Ladyship. Aropa Patra. Based on the aforesaid information, the charge was framed against the petitioner in the memo number झारखंड उच्च न्यायालय रांची का पत्र 16621 2013 के द्वारा प्राप्त हुआ. इस प्रकार यह स्पष्ट होता है कि आप गलत नियम से सेवा में बने रहने हेतु माननीय न्यायालय के आदेश एवं अपनी न्यायिक अभिरक्षा की बात छिपाई है. अन्य महिला के साथ स्वयं से प्रलोभन देकर स्वयं करने हेतु आपके विरुद्ध विभागीय कार्रवाई के तहत आरोप प्रारूप गठित किया जाता है.
Nobody appears on behalf of the petitioner. The learned counsel for the respondents has submitted that in spite of order dated 21/2/2024, no supplementary affidavit has been filed by the petitioner. The learned counsel has also submitted that no relief can be granted to the petitioner as the petitioner stands convicted for an offence under section.
He is released on bail.
Just a moment. For an offence under section 376 of 376 of Indian Penal Code. 420 में acquittal हो गया. 376 of Indian Penal Code, and she submits that she submits that departmental proceeding was also initiated against the petitioner arising out of connected allegation, right? Arising out of the same allegation, and certain more charges were also imposed. She submits that since the petitioner stands convicted, आप हैं? Conviction हो गया ना आपका?
इसमें कन्विक्शन तो जो चार्ज इनका था उनको मेमो ऑफ चार्ज इशू किया गया उस मेमो ऑफ चार्ज
आपने सप्लीमेंट्री एफिडेविट नहीं फाइल किया पर्सुएंट टू द लास्ट ऑर्डर?
ही इज ही कुड नॉट कम
आप हमको ये बताइए, व्हेन यू आर ऑलरेडी कन्विक्टेड आपको क्या रिलीफ हम दे सकते हैं? एट दिस स्टेज आपका एक्यूटल हो जाएगा तब आप जाइएगा, क्योंकि कन्विक्टेड को तो रीइंस्टेटमेंट नहीं हो सकता ना.
That is true. That is true. But my lord, the notice to show cause was issued to the petitioner. Memo of charge has been issued. That is different.
No, that therefore once you are acquitted, you will have your right to say कि इसको revive कर लीजिएगा उस समय.
At least natural justice is required to be followed. We all the matter. Even in the case of conviction.
You have not complied the last order. Why have you not complied the last order?
Last order, my lord, he was ill, my lord. The petitioner had to come to the High Court to issue a affidavit. Now the situation has changed.
अच्छे खासे आदमी को वो ऐसे इल बोलेंगे ना, वो सही में बीमार हो जाएंगे. ऐसा मत किया करिए. 4 बार कॉल किए तो आप तो नहीं बीमार थे? क्या आप भी बीमार चल रहे हैं? वकील साहब नहीं ना बीमार है, क्लाइंट बीमार है आपका.
I was on legs. I was in legs.
Once you have been convicted, no relief can be granted to you.
That's true, madam. But the natural justice system, madam, the charge memo says that I have not stated that I was in jail for some period, madam. That is, madam, the
charge memo is different from the criminal case.
Yes, madam.
Then you will have no benefit of any. Even if you are acquitted in the criminal case, you remember this. I will record it right away. Then you will have no benefit of your acquittal in the criminal case.
Charge memo, what they say, madam?
No, we do not know. I am asking you. If the charge memo is different from the criminal case, then you will have no benefit of acquittal in the criminal case. Are you ready with that? I will record it here.
Madam, what the record said, I am speaking the same.
You have not been able to satisfy this court that you were in custody during that relevant point.
I said, madam,
you have not filed.
He shall come, madam, tomorrow.
He'll come tomorrow. I'll post it day after.
Madam?
I'll post it day after tomorrow. I'll see your affidavit. परसों रखते हैं affidavit लिखेंगे. WPS number 364 of 2023. Counsel for the parties are present. Counsel for the petitioner prays for and is granted time by way of last indulgence to comply the order date time till ये Thursday का डेट दे दीजिएगा. To comply the order dated 21/2/2024. close this case on 1st of April. No further adjournment will be granted for this purpose. देखते हैं.
Item 80, WPS 129 of 2023 along with 19 to 21.
Yes, it has come on the contempt members. I am still my contempt petition in the second case. Because what has happened members, there are 12 junior engineers in the agriculture department and there are 3 writ petition members. Plus in the first writ petition, Dr. Milos, Kam Jadhav 129/23, there were 7 petitioners Milos.
Where is the contempt petition?
Contempt is second case plus contempt
Second case.
785 of 2023 against the interim order.
An interim order has been passed.
Because if they are working, they will not be removed. What has happened, Milos? Kindly have a pleasure first. All these were appointed Milos pursuant to advertisement, etc. upon the sanctioned post. And this person, this Bholanath, is most senior person out of all of them. Milos. This will also will find more of annexure 2, page 27. I will just run through the papers Milos, so that also I will not be required to return back.
No, are we hearing the writ petitions finally?
No, slight facts is required Milos. Only contempt. I am pressing only contempt. What has happened Milos?
We will decide the writ petition. What is the big issue about?
Big issue is Milos.
First, you argue the
out of 12%, 11% has been restored. They have issued the order of restoration, only appointed by one stroke of pen. With respect to this Bholanath, there was also an interim order in the same line with that of the interim order in favor of the.
Which is the writ petition of Bholanath?
First writ petition.
Number 19, sorry 20.
129.
No, PS 2597.
चलिए उसका 2597 का रिकॉर्ड देखिए. कंटेंट के साथ ही साथ डिसाइड कर देते हैं हम केस.
रीट क्लियर गया हुजूर.
हाँ, रीट सुनेंगे ना. आप क्या करना? लीडिंग्स कंप्लीट हो गया ना?
जो प्लीडिंग उस लोगों में तो रिजॉइंडर तक फाइल किया हुआ है, इसमें रिजॉइंडर नहीं है खाली इसमें भोलानाथ में. बट वो जो पूरा इंटायर प्लीडिंग एडमिटेड है, काउंटर बिल्कुल पैरावाइज नहीं है, पूरा एवेसिव है और सब कुछ एडमिट कर लिए हैं लोग. नॉन डिस्प्यूटेड फैक्ट्स का केस है.
From where do you say that on 17/7/2023 you were working?
Grateful, Miss. Kindly see this. First of all, Miss, kindly see this annexure. I'll just try to show. First of all, kindly see annexure.
No, you refer it from the contempt. You want to place your contempt, you refer it from the contempt.
Miss,
That you were working on 17/7/2023 and this order was duly communicated to the respondents.
Para 26 of my writ petition, contempt petition, first may kindly see Miss. Para 27 of the writ petition and para 26 of the contempt petition.
No, you just place your contempt.
Contempt
That
petition.
is, yes.
Para 26 Miss.
Para 26 of the contempt.
What's it?
You are not getting my question. I just want to know from you. Show me that on 17/7/23 you were working.
I was working.
Where?
Yes.
Where? From where do I get?
A statement that I am showing Miss, para 26.
Statement.
Not denied.
Para 26 is what?
Para 26 is my averments. Plus case of hostile discrimination that I am trying to make plus Article 14.
In contempt jurisdiction, we will not see hostile discrimination. We will only see the violation of the code.
Grateful Miss, that I am trying to show.
Yes. Show me one statement from your contempt application that on 17/7/2023 you were working.
Yes, plus that, however, the petitioner and others continued working even after expiry of formalistic extension period with contemplation to grant retrospective extension to use granted since more than 10 years and is thus still working on the post of junior engineer agriculture as is evident from up-to-date attendance report available on biometric attendance system. Consequently, Office of Soil Conservation Officer Chatra recommended for perpetual extension by letter dated 16/3/23 annexure 6 series. Kindly see me annexure 6 series now. Page 31. On 16.3, my lords, he has recommended for extension. It starts from page 31 is the, my lords, forwarding, and the recommendation is page, my lords, page 32. On 16.3, he writes, kindly extend his service from 18/1/23 to 17/1/24 as because अभियुक्ति में देखा जाएगा जो page 32 right column. कार्यालय में कनियमितता नहीं रहने के कारण संविदा विस्तार करना आवश्यक है. I continued working as all were working in different districts, Milos. All 12 persons. Now, Milos, my attendance are there right from paragraph page 33 onward. It is the attendance up to Milos September 23. Page 37 is the last attendance report, Milos. Page 37. It starts from page 33. It goes on up to page 37. 37 is the September 23 is the last attendance report. Now, my lords, kindly see this annexure 7, page 38. In this background, what I am trying to show to lordship, how they are victimizing this for no reason. This is the first order, my lords, which was passed with respect to 7%, page 38.
After 9th of September 23, what happened?
They are not paying me. Not
paying you is one thing.
They are not they are saying that they are not taking work from me.
From where do you get this? You show it from your contempt. When you show that this particular order has been violated, where is your violation?
Yeah, there was annexure 12, page 46.
Petition से दिखाइए,
petition से
ये averment से दिखाइए. Cause of action has to be averred and pleaded in the contempt application. Yes. What is your cause of action to file a contempt application?
This is annexure 12, averment in page 34, para 34.
Para 34. Yes.
That, however, in the meantime, in purported compliance of the order dated 14/23, passed in WPS number 129 of 23, the contemptors came out with one office order number so and so, dated 25/23, by which only 7 petitioners of that case has been restored on duty, but by which not only होगा हुजूर यहाँ पर एक नोट छूटा हुआ है, but also 4 petitioners of WPS number 3621 or 23 have also been restored. जबकि इनके फेवर में कोई इंट्रीम ऑर्डर नहीं था, 3621 के लिए कोई इंट्रीम ऑर्डर नहीं है तो भी रिस्टोर कर दिया उनके लिए. वो जो हम लगाए हैं, treating the order dated 14/23 passed in WPS number so and so in rem. However, in arbitrary and hostile discrimination, the present petitioner has been left out, which amounts selective colorable compliance besides and thereby scandalization so and so. This is the cause of action. All was
restored का क्या मतलब हुआ?
उन लोग को भी हटा दिया था ना
इंटरिम ऑर्डर के पहले.
नहीं काम वो लोग डेली हाजिरी बना रहे थे, ऑफिस जा रहे थे. वो लोग नीचे का कोई ऑर्डर हटाने का डायरेक्टर का नहीं है. डायरेक्टर ने कोई ऑर्डर हटाने के लिए दिया. अब 1 मिनट और समय लेंगे हुजूर. अब ये क्या करते हैं एक्सप्लेनेशन में, पहले सीधी सोकोज में कहते हैं कि
हम उन्हीं से सुनेंगे ना. इट इज बिटवीन द
जिला से चिट्ठी आ गया कि हम काम नहीं ले रहे हैं इनसे.
यस.
No removal order.
Example 5, page 30 of the contempt application, the kind of type copy is also there. Next. The petitioner is a contractual employee and his contract was up to 17th of January 2023. Page 30. Page 30 of the contempt. Annexure is annexure 5.
Okay, it was till 17 January 23.
Yes. And after this period, there is no relationship of employer-employee between the petitioner and the...
No extension on record?
No extension on record, though there is recommendation that my learned friend has referred that there was recommendation to extend their contract. But after the order dated 17th of July 2023, the interim order was passed. The petitioner himself gave a letter that my lord may find at page 47 and annexure 33 and annexure 13 to the contempt application. page 40 and exam 30. This is the representation by the petitioner in response to the order passed by this honorable court. And thereafter we have sought.
I want to read it below. It's my representation. Let me read it below. Kindly permit me to place it. This is my representation.
आप प्लीज बैठ जाइए.
ठीक हो जाता है.
Yes.
Well, after this representation, we sought.
He is seeking reinstatement in service.
Reinstatement in service. This is his application. Now, after this, we sought an report from the concerned authority that my lord will find my so cause is there not so cause on behalf of opposite party number 2 and 3. Annexure A, page 11. Annexure A, page 11. This is the letter by the Bhumi Sanrakshan Padadhikari to the Director Soil Conservation. It says उपर्युक्त विषय के आलोक में सादर सूचित करना है कि संविदा आधारित कनीय अभियंता श्री भोलानाथ द्वारा अपने कार्य का निष्पादन 15/6/2023 तक किया गया. इस अवधि के बाद इनसे कोई कार्य नहीं लिया गया. So then he gave his application and in response to that we have written to the concerned person. It says उपयुक्त प्रासंगिक विषय के संबंध में कहना है कि श्री भोलानाथ पूर्व कनीय अभियंता चतरा के द्वारा 23/8/2023 द्वारा ये सूचित कराया गया है कि उनके द्वारा 17/7/23 तक कार्य किया गया है, जबकि आपके द्वारा पूर्व में निदेशालय को अवगत कराया गया है कि भोलानाथ द्वारा अपने कार्य का निष्पादन 15/6/23 तक कराया गया है. चूंकि यह न्यायिक मामला है, अतः निर्देश दिया जाता है कि तथ्यों की जांच करते हुए इस संबंध में अपना स्पष्टीकरण 2 दिन के अंदर निदेशालय को प्रस्तुत करें. ठीक है. And the report is at the page 14. Annexure C, page 14.
How do you respond to his attendance?
My lord, if that is a biometric device, not anyone can go and punch. But the concerned authority says that after 15/6/2003, my lord, though after 15/6/2023, my lord, no work has been taken from me. Annexure C, page 14, my lord, may I please read? It's a short letter. उपयुक्त विषय एवं प्रासंगिक पत्र के आलोक में सादर सूचित करना है कि संविदा आधारित कनीय अभियंता श्री भोलानाथ के द्वारा अपने कार्य का निष्पादन दिनांक 15/6/23 तक ही किया गया है. इस अवधि के बाद इनसे किसी भी तरह का कोई कार्य नहीं लिया.
आपको क्या बोलना है?
क्या बोल रहे हैं? हमको हटाने का कोई ऑर्डर नहीं लिया जा रहा है. एवरीबॉडी वाज इन द सेम फुटिंग. ऑल डिस्ट्रिक्ट्स. व्हाई दिस हैज हैपेंड? उसके नीचे क्या लिखा हुआ है? सहानुभूति पूर्वक स्पष्टीकरण से मुक्त करने की कृपा की जाए. इट इज द प्लस बैकडेट. कब लिखा गया है? 28/8/23 को. ऑर्डर मेरा है 27/7 का. और ये क्यों आया हुआ वही दिखाना चाह रहे थे. कंटेम्प्ट में हम लगाए हैं एनेक्चर. दिस इज ऑलमोस्ट कलरेबल लेटर्स, बैकडेटेड लेटर्स. एनेक्चर 7 पहले जो थोड़ा सा इसे 2-3 पेज दिखाना जरूरी था, जो थोड़ा समय लगने वाला केस है. एनेक्चर 7 पेज 38 से जो देखा जाए, ये जब 14/2/23 का ऑर्डर आया 7 आदमी का, 7 डिस्ट्रिक्ट्स का, तो उसके बाद ये लोग कब ऑर्डर पारित कर रहे हैं रेस्टोरेशन का? 25/8 को. ये फरवरी का ऑर्डर है, रेस्टोरेशन का ऑर्डर आ रहा है उन लोग का 25/8 को. इसके बाद मेरा ऑर्डर है यूजुअली कब का? 17/7 का. एनेक्चर 8. एनेक्चर 8 पेज में रेलेवेंट इज पेज 41. पेज 41. And इसमें क्या लिखा हुआ है? This is order in the line of the first order. So I will be also governed by the first order, 14/2 order. It is only reiteration. Page 41. 17/7/20. The Learned Counsel for the petitioner submits the petitioner is similarly situated. After all, Article 14 will cover me or not? How the 11% of the same putting same appointment letter will work and 1% will rotate out and say hypertechnical issue. Similarly situated that of the petitioner of WPS number such and such. Learned Counsel for the respondent seeks time to file counter affidavit. Prayer is allowed. Put up the case on 6 weeks. It is made clear if the petitioner is working, he will not be removed. Where is the removal order, my lords? Director has appointed me. Director extends me. There is no order of removal. And the field officer से लोग लिखवा के ले लें कि हम काम नहीं ले रहे हैं. हम तो वहाँ हैं ही. ना हमको उनका कोई ऑर्डर रिमूवल का है, ना डायरेक्टर का है कि उसको हम चैलेंज भी कर सकते हैं, और हमको बैठा दें. अब बाकी 11 आदमी से काम ले रहे हैं, उसका वेतन ले रहे हैं, और अपॉइंटमेंट में हम सबसे सीनियर हैं. सेम अपॉइंटमेंट लेटर है, द सेम स्ट्रोक ऑफ पेन. सो इफ द मेड क्लियर petitioner is working, he will not be removed. Where is the removal order, my lords? Till date there is no removal order. And only crime that this petitioner has committed, my lords, that he has filed a belated representation on 28/8. 28/8. Now let us kindly see what happened. After this order, 17/7, page 42, kindly see below. Why all this problem started? In spite of these two interim orders passed by this court, the director passed an order so-called notice upon the field officers that how you people are taking work in spite of expiry of contract period in January 2021 itself, violating these two interim orders. This is page 42 minutes. Kindly have a pleasure, page 42 minutes. Upon this so-called, the reply came from the field officer in August कि हमको इस सोकोज से मुक्त किया जाए, इनसे हम 15 जून से ही काम नहीं ले रहे हैं, हमको हटाने का कोई लेटर नहीं हुजूर, ना हमको कोई टर्मिनेशन है, ना डायरेक्टर को कोई चिट्ठी है। और इसके बाद जब ये कंटेम्प्ट उन लोगों का फाइल हुआ, कंटेम्प्ट 53323, that contempt order in page annexure 10, page 44, they took time for compliance and all they have been restored by the annexure 12 or 11%, and this Bholanath has been left out only. Therefore, I file another contempt. In any case, how this out of 12%, 1% will be indefinitely treated. This is the crux of the matter, Millers. If you have restored the 11%, restored him also, this poor man.
Restoration means first termination, then restoration.
Therefore, only allowing the work and payments of salary.
What do you mean by restoration?
Kindly see, that is the meaning of page 46 that they have given. What they say, extension of contract for retrospective effect. Page 46 of this contempt petition. This is the crux of the matter, Millers. After they file a contempt petition, Millers, upon page 42, kindly see, Millers, only bear with me, Millers, only 2 minutes more, Millers. Because it's a question of Article 21 of this petition, Millers, right of life, 2 Millers, small children, 13 years he has worked regularly, appointed by just one stroke of pen. Fortuitously, somebody in Chatra district, somebody in Palamun district, somebody in Hazaribagh district. How he will be discriminated in this manner? I isn't the verge of starvation on account of this kind of hyper-technical view taken by them.
So why don't you argue the main matter?
Why, you know, I'm grateful. They will argue tomorrow that you are out of service, no question of regularization.
We will give advantage to you to that.
Regularization issue, if this.
We do not. Yes, you argue the main matter because the orders passed in other cases is also subject to this particular writ petition.
I am ready to argue, Mullah.
Where you argue?
Let Lordship may hear it, Mullah.
Yes, you argue.
It's very. What is the only thing that is coming in my mind? They may argue. That you are not
What
in
they
service.
will argue, we do not know. You want to argue your contempt, you don't want to argue your main writ petition.
No. I am happiest man to argue
So
the
you argue
writ petition.
your main writ petition. Please
Very
start
well,
your
Lordship, hear
argument.
it, Mullah, today itself.
Yes,
I'll argue, Mullah.
you argue.
No problem.
Right. If you succeed, then we will see the contempt records and we'll find out
Grateful,
whether you were there on that
if
particular
ultimately
day or
University
not.
is held that I am entitled to regularization, having satisfied all the requirement of law, and have completed 10 years bona fide appointment, scale salary, all these covered case by the Mullah Kamal Prasad judgment of Supreme Court, and I am sure that I will be able to satisfy my lords that is a fit case for regularization order, Mullah, and restoration of everything. So I am not running away, Mullah. I am ready.
You were appointed by advertisement?
Advertisement.
Advertisement for what? Regular post? Sanction post?
Sanction post.
Contractual post.
Sanction, not contractual post. Kindly see Mullah Annexure 1.
Where is the advertisement?
Annexure 1 of the writ petition, Mullah.
Advertisement.
Advertisement.
No such case can be decided without the advertisement.
Yes.
Where is the
I am
advertisement?
grateful, Mullah. Kindly see this. This is Mullah Annexure 3. हुजूर उसके पहले Annexure 2 हुजूर एक खाली देख लीजिए.
एडवर्टाइजमेंट पहले दिखा दीजिए. आप हमारे क्वेश्चन से शिफ्ट मत किया.
ठीक है हुजूर, हम खाली 2 पहले आना चाह रहे थे, वो दिखाना चाह रहे थे कि सैंक्शन कैसे पोस्ट हुआ, गवर्नमेंट ऑफ बिहार से आया पोस्ट, तो फिर उसका एडवर्टाइजमेंट हुआ.
एडवर्टाइजमेंट दिखाइए कि वेकेंट सैंक्शन पोस्ट पर आपका रेगुलर अपॉइंटमेंट दिखाइए.
ऊपर में दिखा जाए पेज 31. भूमि संरक्षण निदेशालय झारखंड रांची के अधीन स्वीकृत, पेज 31. कि भोला कौन सा रेट करेक्ट मलर्स 2597. Annexure 3 opening line. भूमि संरक्षण निदेशालय झारखंड रांची के अधीन स्वीकृत पेज 31 टाइप कॉपी है स्वीकृत कनीय अभियंता कृषि अभियंता वेतनमान
आपका पेज नंबर टैली नहीं करता।
पेज 31 हुजूर
पेज 33 है इसमें डेटेड 27/12/2012।
हाँ हुजूर वही है
लेकिन आपका पेज नंबर टैली नहीं करता।
27/12 हुजूर अपॉइंटमेंट लेटर है
ये अपॉइंटमेंट लेटर है
हाँ।
आपका वो कहाँ है?
वो एडवर्टाइजमेंट पेज 31 एनेक्सर 2 एनेक्सर 3
हाँ बताइए।
एनेक्सर 3 पेज 31
हाँ पढ़िए।
हाँ इसका टाइप कॉपी हुजूर ओपनिंग लाइन
पढ़िए,
पर
पढ़िए।
भूमि संरक्षण निदेशालय झारखंड रांची के अधीन स्वीकृत कनीय अभियंता कृषि अभियंत्रण वेतनमान 9300 से 34,800 ग्रेड पे 4200 के 22 कनीय रिक्त पदों के विरुद्ध पूरे राज्य में संविदा पर सेवा प्राप्त करने हेतु निम्न योग्यता अर्हता वाले इच्छुक भारतीय नागरिकों से विहित प्रपत्र में दिनांक सो इट वाज अगेंस्ट द फुली सैंक्शन पोस्ट इन a pay scale post they invited application in the garb of contract only so nomenclature was only contract correct
So according to you
what's it
you were appointed in 2012.
12
Are
Where
you
is the sanction
governed?
post?
Are you governed by any
Judgment.
regularization? No. Scheme of regularization?
scheme of regularization was 10 years Uma Devi case and irritated in the Kamal Prasad
Kamal
I will cite Mulas
No. I just want to know
What's it?
that what was the minimum criteria for
10
regularization?
years 3 criteria
10
Mulas.
years as on
date of working completion when I claim the regularization total period that has been decided in the Kamal Prasad case by the Supreme Court and Mulas it has been clearly held that only 3 requirements is there sanction post no backdoor entry and qualification
So it is a scheme by which you claim 10 years as on any day you want or it is 10 years as on the date on which the circular was issued.
I am not on circular. I am in the Article 141 law led by the Supreme Court.
We will be there. Where is that judgment? Kamal Prasad, which says that any date, suppose a person is appointed in 2014, right? By virtue of that circular, he will continue to claim regularization.
Plus, the moment I complete 10 years, I have a right of regularization.
So, under which circular?
Circular, I am not on. I am more than circular. In a case, the circular came in 2019. That circular the state wants to rely. That circular has not been held to be valid. It's executive norms. It will not override 141. It was recently our own High Court has decided one matter, this N.N. Tiwari matter, on remand by the Supreme Court. What has happened? Supreme Court remanded 2018. They did not follow it. Even the Supreme Court order again rejected the claim.
Where is that order? Where is that order?
आज तो हुजूर हम सब लिख के लाए हैं मेरे पास लिस्ट है
लेके आए हैं लेकिन लेके नहीं आए
अरे लेके तो हुजूर हम कल दे देंगे जजमेंट सारा
नहीं ऐसा
फैक्ट्स प्लीड कर देंगे
पार्ट में नहीं होता ना
हुजूर हमारा सिर्फ आज ये विनती था हुजूर कि इनसे ये खाली कहा जाए कि जो 11 आदमी रिस्टोर है
अब हम आपका फाइनल सुन रहे हैं अब आज फैक्ट्स आप बोल दीजिए आपको जो जजमेंट लाना है आप हमको शाम तक दे दीजिए और कल आपका ऑर्डर आप लेके जाइए वी विल डिसाइड इट फाइनली ये कंटेम्प्ट में हम लोग कुछ नहीं डिसाइड करेंगे कंटेम्प्ट अगर होगा इंट्रीम ऑर्डर का वी विल सी व्हाट एट बेस्ट यू कैन हैव द बेनिफिट ऑफ यू नो जो आपको डिसकंटिन्यू किया या जो आपने अपना आपका
one small prayer, Lordship. Kindly put it on tomorrow, Lordship.
No, let him plead the facts.
I told just arguing before that we need some time because as per the
आपको टाइम चाहिए तो कंटेम्प्ट फेस करिए
I am an 18.
Why have you permitted
I am
him
a
to
serial 18, Lordship. I am 18 now.
These are all batch matters, no?
Yes.
Isolated case decide होगा क्या?
Only praying for tomorrow, Lordship. If Lordship.
It will go for tomorrow because I have to hear his facts today. For his further arguments, I'll place it tomorrow. Right? Because he will cite some judgments. Judgments का citation दे दीजिए.
ठीक है तो tomorrow ही रख दिया जो
नहीं tomorrow नहीं आप अपना facts बहस
सेकंड हाफ में जो दो मेंशन केस
तो you are seeking time. I will adjourn it. एक साल. टुमारो हम कहाँ मना कर रहे हैं आज आपको अभी आधा पौन घंटा से सुन रहे हैं ठीक है अभी जब सुनने के कंटिन्यूटी में हम आ रहे हैं तो फिर आप बोलते हैं दूसरा कोर्ट में जाना है अब जाइए दूसरा कोर्ट में फिर
वो ये क्या बोले कोर्ट नंबर 9 में तो हुजूर सीधे स्टे वैकेट हो जाता है पहले ही राउंड में हुजूर बहुत संकट है हुजूर हम लोग के साथ हुजूर पहला राउंड में वहां टाइम
नहीं जब आप एक केस में बहस शुरू कर दिए हैं
हुजूर वहां तो यहां तो हुजूर क्या टुमारो भी हो जाता है
नहीं हम ये नहीं हम ऐसा इसको अप्रिशिएट नहीं करते हैं कि आप जो है एक मिड्स ऑफ द केस में छोड़कर आप दूसरा कोर्ट में चले जाइए ये कोई भी कोर्ट
ठीक है,
एप्रिशिएट
तो हम
नहीं
ये विनती
करेगा।
करते हैं जो इसको 3 बजे रख दिया जाए खाली।
नहीं, आपके टाइम से नहीं होगा, वी विल हियर इट इन दैट।
21 IA is pending.
व्हाट आइए
IA for amendment your leadership and IA for rejected.
आप सपोर्ट कर रहे हैं पिटीशन?
No.
क्या चीज का अमेंडमेंट?
अब हुजूर वही क्या है सो बता
नहीं,
देते
क्या
हैं।
चीज का अमेंडमेंट?
वो जो 3 आदमी का जो सेकंड रीच था, 4 आदमी का, उन लोग का तो हम अमेंडमेंट किए थे, हटा दिया था। वो अमेंडमेंट अलाउ भी उसको तो भी रिस्टोर कर दी उसको पहले ही।
हमको उससे मतलब नहीं। आप अपना आर्गुमेंट करिए, आप अपना मेन रिलीफ पर आर्गुमेंट। यू विल सी व्हाट
मेन रिलीफ यही है हुजूर कि डिक्लेरेशन सीख कर रहे हैं कि 10 इयर्स हो गया है, रेगुलर पोस्ट है, वैलिड अपॉइंटमेंट है, वैलिड मोड है, वैलिड क्वालिफिकेशन है, इसलिए आई परफेक्टेड माय राइट ऑफ रेगुलराइजेशन एंड रिटेनमेंट इन द सर्विस एज पर द लॉ लेड डाउन
बाय द सुप्रीम कोर्ट।
By the Supreme Court in such and such cases.
That's right.
I'll rely upon those cases, Milors. Lordship may consider it to be read with Milors Olga Teli case that was decided by the Supreme Court in Kamal Prasad case. Affirmed in Milors this in contempt proceeding in the Supreme Court. Supreme Court expanded rather the regularization was granted from 87 on the assistant engineer post. Honorable Supreme Court in the contempt proceeding says no, you regularize from the junior engineer from 81. So that is the Milors. According to me, Milors, I am squarely covered by that judgment.
That's not by their scheme.
Not,
You are not concerned with their scheme for regularization.
No, scheme I am saying why? Because in a scheme, I am not coming.
Oh, that's
if I am coming in the law fold of the land article 141, a scheme will not come in my way. Because the scheme laws regarding a scheme that has been not endorsed by this court recently in the another coordinate court order, the Lordship has held that this scheme, the cut-off date of 19 is not in accord with the Supreme Court mandate. That scheme has not been endorsed by the coordinate bench taking the account
that
of the
scheme
Supreme
has
Court.
been set aside.
It has been held that it is not in consonance with the Supreme Court order. So the Supreme
So you forget about the scheme. You only rely upon Supreme Court judgment.
If I am covered in the mandate of 141, I think that will override and binding upon the state. The executive rule, which is a scheme, if we not having a legislative force, will not also override the
We'll
Supreme
take care
Court
of
mandate.
The learned counsel for the parties are present. अभी तो second आपने सुनेंगे आपको facts.
Tomorrow the judgment वाले सब लेके आ जाते हैं जो हुजूर का हुआ कि पूरा कंपाइलेशन हम बना के ले आएंगे हुजूर कल।
तो आज हमको forward करिए।
अच्छा ठीक है तो हम कोशिश करते हैं शाम में सब बना कर।
कोशिश अगर कल आप लेके आएंगे तो हम एडजर्न कर देंगे 2 महीना के लिए। आज आप दे देंगे तो हम आपका केस
फोटो करा के हार्ड कॉपी देते हैं जरूर लाइब्रेरी से मंगाते हैं।
The learned counsel for the parties are present. The learned counsel for the petitioner submits that so far as the scheme for regularization as framed by the respondents is concerned, the case of the petitioner is not covered. However, the petitioner is seeking relief of regularization on the basis of judicial pronouncements made by the Honorable Supreme Court, which is binding on this court under Article 141 of the Constitution of India.
The state government is also.
Sorry?
And the state government is also bound by that.
आप ऑर्डर डिक्टेट कर रहे हैं?
Sorry,
he submits that the copies of the judgments which he is relying upon with the paragraph number will be submitted before this court during the course of the day. Post this case tomorrow.